Hello, good morning, and welcome to Byju's exam prep. Yesterday, we initiated a discussion on citizenship, and there we discussed the Citizenship Act of 1955. What are the 5 ways by which one can acquire the citizenship of India? By birth, by descent, by registration, by naturalization, and by incorporation of a territory. And then there are 3 ways by which one can lose his or her citizenship. One is renunciation through a voluntary act. Then there is termination. If you have acquired the citizenship of another country without renouncing your citizenship, Indian citizenship, the central government will terminate your citizenship. Then there is something called deprivation. Deprivation what? If you have acquired Indian citizenship through registration or naturalization, but you have acquired citizenship through fraud, through misrepresentation, through concealment of facts, your citizenship can be deprived from you. Similarly, if you are disloyal to the constitution, or if you have stayed outside the territory of India for 7 years continuously, then your citizenship can be deprived. Then there are 3 concepts. One, person of Indian origin, overseas citizen of India, and non-resident Indian, NRI. PIO, which was a scheme launched by the Ministry of Home Affairs way back in 2002, overseas citizen of India, which was under the Citizenship Act of 1955, and then NRI is basically covered under the Income Tax Act. Who is a person of Indian origin? A person who once held an Indian passport. Now is not the citizen of India, but once held an Indian passport. If you want, you can apply for PIO card. Using this card, you can enter India without visa for 15 years. But overseas citizen of India, if you were once the citizen of India, but now you are a foreign national, if your parents were citizens of India, or their parents were citizens of India, or they were eligible to become the citizens of India on 26 January 1950 when the Constitution was enacted. If you want, you can apply for an overseas citizen of India card, through which you can enter India without visa for life. Then in 2015, PIO card was discarded. PIO scheme was merged with the OCI scheme. And now we don't have a PIO, we only have an overseas citizen of India card holder scheme, under which if you are a foreign national but were once the citizen of India, if you are a foreign national but once your parents were the citizens of India or eligible to become the citizens of India, you can apply for the OCI card. And those who have the PIO card, they can convert it, or should we say upgrade it to the OCI card. But there is no such concept as dual citizenship. Because when you look at this term, overseas citizen of India, you might get a sense, a misleading sense, that we recognize dual citizenship. Because one, you can be the citizen of India or you can be the overseas citizen of India. But there is no such concept as dual citizenship. This is just a benefit given to the diaspora. Then non-resident Indian. If you are residing in India for less than 182 days in a financial year, you are a non-resident, which means your tax liability is not in India, your tax liability is in the country where you are operating from, where you are earning, where you are raising income. But then these residency rules were misused, abused. And that is how 2 years ago, the central government decided to change the definition of NRI. Now, if your income from India is above 15 lakhs, and you are residing in India for less than 120 days, you are a non-resident Indian, you don't have to pay tax in India. But if your annual income is more than 15 lakhs, and if you are staying in India for more than 120 days, initially it was 182 days, now it is more than 120 days. That means we have reduced the time period. You become the resident of India, you have to pay tax in India. Clear? Then we looked at the Citizenship Amendment Act of 2019. What are the provisions of CAA 2019? Normally, illegal migrants are not eligible for citizenship. Because after 1987, we have changed the rules. Rules in the sense, now if a child is born on the soil of India if one of the parent is an Indian and the other is not an illegal migrant. Only then can this child become the citizen of India. So illegal migrants, neither they were eligible for citizenship nor their children were eligible for citizenship. Citizenship door was closed for illegal migrants. But then in 2019, the parliament enacted a law known as Citizenship Amendment Act. That means you are amending the Citizenship Act of 1955. Because I've told you, we have amended this law multiple times. And the last amendment was in 2019. Under this law, if you are from Pakistan, Afghanistan, and Bangladesh, but you belong to the 6 religious minorities, Hindus, Christians, Sikhs, Buddhists, Jains, Parsis, and if you have entered India on 31st December 2014 or before 31st December 2014, you are not deemed as illegal migrants. When you are not deemed as illegal migrants, that means who are you now? You are a legal migrant, and legal migrants are eligible for citizenship. And these migrants will be eligible for citizenship through the route of naturalization. But for naturalization, you should have ordinarily stayed in India for 11 of the last 14 years. But for this specific group of migrants from Pakistan, Afghanistan, Bangladesh, for them this period of naturalization, this period required to acquire citizenship was reduced from 11 to 5 years. Then we have looked at some of the arguments in favor of Citizenship Amendment Act. Then we started a discussion on arguments against Citizenship Amendment Act 2019. And the first argument against it is it violates secularism. And secularism, the Supreme Court has said repeatedly that secularism is part of the basic structure of the Constitution. Basic structure of the Constitution, which no law passed by the Parliament, not even a constitutional amendment, can violate. But how does CAA violate secularism? Because you are making religion as a qualification to apply for citizenship. But sir, if we do not pass this law, then how can we provide citizenship to those individuals, to those migrants who have come to India after fleeing these 3 countries where they are persecuted because of their religion? All you could have done, all the parliament could have done, without even mentioning religion. If at all you wanted to provide citizenship to those people who have migrated to India, you could not have mentioned religion at all. Even without mentioning religion, you could have given them citizenship. How? All you had to do, all you had to write was that from Pakistan, Afghanistan, and Bangladesh, all the people who have fled religious persecution, and if they have come to India on or before 31st December 2014, they will not be deemed as illegal migrants. That means we will give them citizenship through the route of naturalization. Which means, what is your objective? To provide citizenship to those who have migrated from these 3 countries to India because they were being persecuted because of their religion in these 3 countries. You could still have provided citizenship to them even without mentioning religions such as Hindus, Christians, Jains, Buddhists, Sikhs, Parsis. Even without mentioning their religion, you could have said all the people, migrants from Pakistan, Afghanistan, and Bangladesh, who have fled these countries because of religious persecution, and if they have come to India on or before 31st December 2014, they are eligible for citizenship without mentioning their religion. And when you are not mentioning the religion, you are even then covering these religions. Because who is facing religious persecution in Pakistan, Afghanistan, Bangladesh? These religious minorities. So by mentioning the religion, you are specifically violating secularism. You are making religion as the qualification to become the citizen of India. You could have said All those facing religious persecution can come to India, we will give them citizenship. Since you are specifically mentioning religion and making religion as a qualification to apply for citizenship, you are violating secularism, which is part of the basic structure of Indian constitution. Then something else. Article 14 of the constitution, when we looked at the arguments in favor of CAA, there we discussed that Article 14 has not been violated. Why? Because Article 14 talks about equality before law and it talks about equal protection of the law. Equality before law primarily means that law cannot discriminate. Law cannot deny equality. So if Law Citizenship Amendment Act is only talking about Hindus, Christians, Buddhists, Jains, Parsis and Sikhs, but excluding Muslims, you seem to be violating Article 14, which is equality before law. But then the second point is equal protection of the law, which means you can group people based on certain qualifications. This classification is possible. So you are classifying all the religious minorities who are facing persecution, and you are excluding that religious community which is persecuting, which is responsible for their oppression. So you are clubbing all the religious minorities in one group, you are separating another religious community which is responsible for their persecution. So you are creating two different classes. This is okay. But then, according to Anwar Ali Sarkar judgment of 1952, when you are making this differentiation, when you are creating two different classes, how you segregate them, that is also important. What is the rationale behind segregating them? That is also important. On what grounds can you segregate them? That is important. So if you are segregating them because of their religious ideology, yes. But if you are segregating them because of religion, which in section 377 judgment, Justice Indu Malhotra, what she said, Article 15 talks about that there can be no discrimination only on the grounds of religion. Article 14 does not talk about grounds. What does that mean? Article 14 says equality before law, equal protection of the law. It does not talk about that there can be no discrimination only on the grounds of religion, race, caste, sex, place of birth. Those grounds on which the state cannot discriminate, that is mentioned under Article 15. But Article 15 is available to citizens. It is not available to foreigners. And CAA talks about foreigners from Pakistan, Afghanistan, Bangladesh. So Article 15 is not violated. But Justice Indu Malhotra said, let's fuse Article 15 into Article 14. If Article 15 says that there can be no discrimination on the grounds of religion, which means Article 14 would then mean that if you are denying equality only on the grounds of religion, that is unconstitutional. Because on the basis of the core intrinsic traits of an individual, such as sexual orientation, such as religion, you cannot make discrimination. So if Article 15 talks about grounds on the basis of which state cannot discriminate against its citizens, same grounds cannot be used to discriminate under Article 14. That's how Justice Indu Malhotra has fused Article 15 with Article 14 on the basis of core intrinsic traits of an individual, such as religion. You cannot be discriminating against anybody. When you can't make religion as the basis of discrimination, but CAA makes religion as a qualification to apply for citizenship, that is why CAA is unconstitutional. This matter is before the court. A 5-judge constitution bench of the Supreme Court will hear this matter, whether CAA violates constitution or not, whether it is constitutional or not. And there, the government lawyer, the Attorney General of India, will have to defend this law. And how will this government defend this law? For that, we need to again understand Article 14. Article 14 not only talks about equality before law, equal protection of the law, it also gives you a right against arbitrariness. What is right against arbitrariness? For example, the first example that I gave you in our first class, all those students who joined the class between 6 to 7, you cannot ask me any question. Full stop. All the students who joined between 7 to 7:15, they can ask me 10 questions. And all the students who joined the class after 7:15, they can ask me only one question. On what grounds I'm making these rules? Arbitrary grounds, without any logic, without any sense. What is the logic behind not disallowing students who joined the class between 6 to 7 from asking questions? And why are we providing only a 15-minute window between 7 to 7:15 where you can ask me questions, and after that you can ask me only one question? This smacks of arbitrariness. This seems that this is not well thought of rule issued by Byju's. If I would have said instead that all those who have the law background, they can ask me only a question, one question. But those who are from science background, they can ask me 10 questions. Those who are from commerce background, they can ask me 10 questions. So I'm classifying students basis on whether you have the prior knowledge of polity, prior knowledge of law. If you're a law student, you can only seek clarification. But if you are not from polity background, law background, you have absolutely no idea about this subject, you can ask me 10 questions. So I am classifying people, classifying students, but on the basis of sound logic, real logic. But what is the logic? That all those who join between 6 to 7, they cannot ask me questions. All those who join between 7 to 7:15, they can ask me 10 questions. After that, you can ask me only one question. This is arbitrariness. And right against arbitrariness is a fundamental right under Article 14. And now the Supreme Court will ask the government, prove to us that your law is not arbitrary. How? Why have you chosen only Pakistan, Afghanistan, Bangladesh? Amongst all the neighbors that we have, why have you chosen only Pakistan, Afghanistan, and Bangladesh? Your selection of countries seems arbitrary. Why have you selected only Hindus, Christians, Buddhists, Jains, Parsis, and Sikhs, and not other religious communities? Your decision to only include these communities smacks of arbitrariness, reeks of arbitrariness, and as such, this law is unconstitutional. The government will be asked why Pakistan, Afghanistan, and Bangladesh were chosen. The government may say, sir, because these countries were part of undivided India. So during the time of Ashoka, Afghanistan was also part of us. So that is why Pakistan, which was part of us, Bangladesh, which was part of us, Afghanistan, which in ancient India was also part of undivided India. That is why we have chosen only those countries which were previously part of India, such as Pakistan, such as Afghanistan, such as Bangladesh. The question can be asked by the court, what about Nepal? It was also part of India once upon a time. What about countries in your neighborhood such as Bhutan? Then you could also have said that once upon a time it was also under the territory of India. Why not Tibet? Once upon a time our influence was there in Tibet as well. So because you have chosen countries such as Pakistan, Afghanistan, and Bangladesh, because of your logic that they were once part of India, why not include also all those countries which were once part of India? Which means your selection of these countries is arbitrary. CAA is unconstitutional. The government may come up with another argument. No, it's not because of this that we have chosen these countries. We have chosen these countries because these countries have a state religion. These are not secular countries. These are theocratic countries where state has a religion. And that is why we have chosen these three countries, because they have a state religion, where because they have a state religion, the religious minorities have been discriminated against, persecuted because of their religion. The court can ask, why not Myanmar? In Myanmar also they have a state religion. Why not Sri Lanka? They also have a state religion. So you are singling out these three countries because they have a state religion, but you're excluding other countries in your neighborhood which also have a state religion. Your selection of countries is arbitrary. CAA is unconstitutional. The government may come up with another argument. The government may say, no, we are choosing these three countries because of the degrees of harm. Degrees of harm in the sense, more harm is committed against the religious minorities in these three countries. That is why if we look at our entire neighborhood, where do we see most inhumane practices perpetrated against religious minorities? We see that in Pakistan, Afghanistan, and Bangladesh. Since religious minorities in these three countries are more persecuted, that is why they are more harmed. That is why we have chosen these three countries. The court can ask, what about Rohingyas? A minority in a country known as Myanmar. Myanmar also has a state religion. Buddhism has a state religion, where these Rohingyas are being persecuted. Rohingyas can be Hindus as well. Rohingyas can be Muslims as well. But Rohingyas are predominantly Muslims. They are thrown out of Myanmar. And if we look at United Nations, it has said the most religiously persecuted community today are the Rohingyas of Myanmar. They have also fled Myanmar and joined other countries, traveled to another countries such as Bangladesh and India, because the degrees of harm, if on the grounds of degrees of harm, where against which community more persecution has been carried out, the most persecuted community right now are the Rohingyas of Myanmar. So why have you excluded Myanmar and included Pakistan, Afghanistan, Bangladesh? Your selection of countries is arbitrary. The government may still come up with another argument and say this classification is only on the basis of religious minorities. That means we are not talking about Sri Lankan Tamils because they are being persecuted because of their ethnicity. Myanmar, since you have said Rohingyas can be Hindus as well as Muslims. So Rohingyas, yes, they are persecuted in Myanmar, but not primarily because of their religion, but primarily because of their ethnicity. That is why we have not included Myanmar. The court will ask, when you are implementing intelligible differentia, you are classifying groups, and you are saying Hindus, Christians, Buddhists, Jains, Parsis, and Sikhs, they are persecuted, and Muslims are not included because they are the persecutors. Why have you excluded Jews? Are Jews not persecuted? Why have you excluded atheists? Are atheists not persecuted in Pakistan, Bangladesh, and Afghanistan? In fact, in Bangladesh, there was a secular blogger who wrote secular columns. He was killed by the state. In Pakistan, every now and then, the secular atheists are being killed because of their ideology. So by excluding Jews, by excluding atheists, you're making religion as a qualification to apply for citizenship, which means your selection of communities is arbitrary. And once your selection of communities is also arbitrary, CAA is unconstitutional. Why December 31, 2014? That was the key question that students were asking repeatedly since yesterday. Sir, why this date was chosen? Even choosing this date is arbitrary. And on this ground, CAA is unconstitutional. Why? Because what is the logic? The government, by introducing this bill in the parliament, has not explained the reason, the rationale behind having this date 31st December 2014. There is no justification whatsoever. There is no argument whatsoever. There is no clarification whatsoever. The government has not said why we have chosen this date as a cutoff date to apply for citizenship. But one gentleman who is right now the Chief Minister of Assam, Shri Himanta Biswa Sarma, he gave an argument justifying December 31, 2014 as the cutoff date for citizenship. Cutoff date in the sense, all those who have joined India, come to India, migrated India on or before 31st December 2014, they are eligible for citizenship through CAA 2019. The government has not explained the reason why. The government has not told why we have included this date. In fact, the law is silent. It only talks about date. It does not talk about why this date has been fixed. But Himanta Biswa Sarma came up with an argument. He said, we have chosen this date, 2014, because of a reason. So what is the reason? The reason is Modi ji came to power in 2014. Okay. Prior to 2014, there was a lot of illegal migration. When there was a lot of illegal migration, after Modi ji came to power, illegal migration stopped. So when illegal migration stopped in 2014, we don't have to take into account period after 2014, because after 2014, there is no illegal migration. And that is why this date has been chosen, 2014. But even if till 2014, illegal migration into India continued, why are you only talking about 6 religious minorities and excluding the Muslims of Rohingya, excluding the atheists of Pakistan, Afghanistan, Bangladesh, excluding the Jews from these 3 countries, excluding the Sri Lankan Tamils, excluding others in your neighborhood? This smacks of arbitrariness, and right against arbitrariness is a fundamental right under Article 14. And Article 14 applies to foreigners as well. Something else. According to Faizan Mustafa, who was previously Vice Chancellor of the Nalsar University of Law, a very prominent constitutional expert, he says CAA is like Israeli law of return. Because in Israel, how can you become the citizen of Israel? Who can become the citizen of Israel? No matter where you are, if you are a Jew, whether you are residing in India or Pakistan or Bangladesh or US or Germany, North Pole, South Pole, deep in the ocean, no matter where you are, if you come to Israel, we will give you citizenship. That means Israel has religion as a qualification to apply for citizenship. If you are a Jew, no matter what, no matter where you are residing, if you come to Israel, we will give you citizenship. So Israel says, return to your motherland, return to your original land, return to your sacred land, which is Israel. Come to us, we will give you citizenship. In the similar fashion, you are calling CAA, Faizan Mustafa calls CAA as India's law of return. All those non-Muslims, you can come to India, we will give you citizenship. Religion as a qualification to get citizenship is there in theocratic countries, not in a secular country like India, where secularism is part of the basic structure. Hence, CAA is unconstitutional. Something else, Article 11 and CAA. Kapil Sibal, I gave the argument of Kapil Sibal yesterday, wherein Kapil Sibal had said that Parliament should not even discuss Citizenship Amendment Bill when it was a bill discussed by the Parliament. Once Parliament passed this bill, it became a law, it became an act. And there we discussed that Article 11 is not violated. Why? Because Article 11 gives power to the Parliament to regulate all matters related to citizenship. That's what Dr. B.R. Ambedkar had also said. B.R. Ambedkar had said that Article 11, we don't have the intention of laying down a permanent law of citizenship, because that's the power we are giving the Parliament. Parliament, you enact a law, and through this law, you decide, regulate all matters related to citizenship. But a law passed under Article 368, which is a constitutional amendment, you amend the constitution using Article 368, or an ordinary law, neither an ordinary law nor a constitutional amendment act under Article 368 can violate basic structure of the constitution. And if CAA is an ordinary law, but it violates basic structure of the constitution, which is secularism, that is why Kapil Sibal is right. Parliament did something violative of the constitution's basic structure by passing such a law which attacks the secular fabric of India. And that is why even Article 11 is violated. Because under Article 11, yes, Parliament has the power to regulate all matters related to citizenship, but Parliament, even under Article 11, does not have the power to violate basic structure of the constitution. But something else, law and the lie. And for that, we need to understand Assam Accord. Of 1985. In Assam, there was a movement against illegal migration. So people in Assam, they were fed up of illegal migration. Migration not of a particular religious community, migration not of people from other countries, migration of all those people who are not Assamese. So whether you are Bengalis, or whether you are Odias, or whether you belong to other parts of India, or whether you are from Bangladesh, no matter where you are, what your religious community is, we do not want non-Assamese in Assam. We want to put an end to the illegal migration of non-Assamese into Assam. And that is why in 1979, a massive movement was launched in Assam, led by All Assam Students Union. What was their principal objective? Their principal objective was identify these illegal migrants, arrest them, and deport them. Whether these individuals are from Bengal or Odia or Bangladesh, arrest them, deport them back to their areas. We do not want illegal migration in Assam. And that is why census, which is carried out every 10 years, this census could not be carried out in Assam in 1981 because there was a massive uprising, massive movement against illegal migration. And for 6 years, this movement continued. This movement ended in 1985 with the signing of the Assam Accord, which was signed between the central government. Rajiv Gandhi was the Prime Minister at that time, the state government, and the protesters led by All Assam Students Union. On what grounds was this movement stopped? Because it was stopped that we will implement NRC. What is NRC? National Register of Citizens. This National Register of Citizens is basically a database which includes details of only the citizens of India. So all those who are the citizens of India, their names and details are mentioned in this database known as National Register of Citizens. It was for the first time and the last time updated for the entire country in 1951. Right after the commencement of the Constitution, when we had to be absolutely sure who are the citizens of India, who are not the citizens of India, this database, National Register of Citizens, was updated. And that was the first and the last time. The demand of the protesters in Assam is, update this National Register of Citizens specifically for Assam, so that we can implement NRC in Assam, so that we can identify who are the citizens of India, who are not the citizens of India. So those who are not the citizens of India, they should be arrested and deported back to their countries, so that this Assam can remain only for the Indians. And for that, dates were prescribed. What were the dates? All those who have entered Assam before 1st January 1966, because when the negotiations started between the central government, the state government, and the protesters led by All Assam Students Union, it was argued that we can't go back to the 1950s or 1940s or 1930s. So we have to put a limit to some cutoff date. And for you, let's agree on 1st January 1966. Whoever has entered Assam before January 1, 1966, they are the citizens of India. We will not touch them. Protesters said, okay. But those who join or enter Assam between January 1, 1966 to 24th of March, 1971, those will also remain the citizens of India, but they will have no political rights for 10 years. After 1966, protesters said there was a lot of movement, illegal migration into Assam from other parts of India. They were working in the tea plantation gardens. They were working in other industries in Assam. And because of which our demography, our culture has been changed. So we don't want them as well. Said, but these are Indians. How can we stop them from coming to Assam? Said, okay, they will also remain Indians, but for 10 years, they should not have any political rights. What does that mean? They cannot vote in the assembly elections in Assam. They cannot contest Assam elections. After 24th March 1971, they will become the citizens of India. But those who have entered Assam before January 1, 1966, they are the citizens of India. Said, okay, those who entered Assam between January 1, 1966 till 24th of March 1971, they are the citizens of India, but for 10 years, they will have no political rights in Assam. The government said, okay, Assam Accord is signed. But those who join or enter Assam on or after March 25th, 1971, those are to be identified, those are to be arrested, those are to be deported. Why 25th March 1971? Because something happened on this date. What happened? Operation Searchlight was launched by Pakistani army. West Pakistan, East Pakistan. These were the two parts under Pakistan. But East Pakistan was dominated by the Bengali-speaking population. And because of their language, they were discriminated. And then there was a massive movement in East Pakistan. What they wanted to come out of Pakistan. They wanted to establish an independent country. And they did establish an independent country known as today Bangladesh. And India played a very important role in this liberation of Bangladesh. So in 1971, there was a war between India and Pakistan, which led to the emergence of Bangladesh as an independent country. But Pakistani army on 25th March 1971 launched an operation known as Operation Searchlight. They specifically targeted those who are supporting India. In East Pakistan, who are the supporters of India? Who are supporting Bangladesh's emergence? Who are supporting the secession of East Pakistan from Pakistan? All those are to be identified, killed, and that is why and how Pakistani army raped, killed, mutilated hundreds and thousands of citizens in East Pakistan. And then fearing Pakistani army, millions of people in East Pakistan, they started migrating to India. And majority of them migrated to Assam because Assam is closer. Now the Assam agitators who signed this Assam Accord, they said all those who have entered Assam after 25th March 1971, because majority of them are the illegal migrants who fled Bangladesh, who fled East Pakistan, came to Assam. They have changed our demography and we will not tolerate them. and specifically all these people will be identified, arrested, deported. For that, NRC will be updated in Assam. And that is how in 2019, the final NRC was updated for Assam only, on the directions of the Supreme Court. Because one gentleman approached the Supreme Court few years ago. The gentleman was Sarbananda Sonowal. Sarbananda Sonowal, who is now the Union Minister, previously he was the Chief Minister of Assam, he approached the Supreme Court and said, "Dear Supreme Court, it has been decades since the signing of Assam Accord, but NRC has not been implemented in Assam." The Supreme Court said, "We direct the conduct of NRC in Assam." So specifically for Assam, NRC was conducted. And when NRC was conducted, what was the objective? To identify those who have entered Assam on 25th March 1971 or after 25th March 1971. Those are to be identified, arrested and deported. And that is how NRC was implemented. And when NRC was implemented, close to 19 lakh people in Assam failed to prove citizenship. 19.5 lakh or more than 19 lakh individuals in Assam who are residing in Assam failed to prove their Indian citizenship. That is why their names were not mentioned in the NRC. And some people say, not me, that government was thinking that majority of these illegal migrants would be the Muslims. So when majority of these illegal migrants are Muslims, we will get rid of them, problem solved. When this NRC list was published, and these 19 lakh individuals were identified who could not prove their citizenship, the government realized that majority of them are Hindus. Majority of them are the Bengali Hindus who had migrated to Assam. They have also failed to prove their citizenship. And for that reason, they passed CAA. What is the CAA? Even if you are an illegal migrant, but what is the cutoff date now? December 31, 2014. If you have entered India from Pakistan, Afghanistan and Bangladesh, and you belong to 6 religious communities, we will give you citizenship. That means identify out of these 19 lakh who are from Pakistan, Afghanistan, Bangladesh, or who are non-Muslims. And those who are non-Muslims, we will give them citizenship under CAA. Now, some people say this is the law and the lie. Previously, these 19 lakh individuals, when they presented their documents, they approached the authorities and said, "Look at these documents. We are the citizens of India." But these documents could not satisfy the authorities. Authorities said, "No, you are not the citizens of India." Now the CAA law is telling them to lie. Lie now. Don't say we are the citizens of India. Say we have migrated to India from Pakistan, Afghanistan, Bangladesh, and we belong to these 6 religious communities. Just lie and we will give you citizenship. Because in Assam Accord, the cutoff date was 25th March 1971. For CAA, the cutoff is December 31, 2014. That is why Assam is again up in arms. That is why against CAA, Assam protested. The protesters in Assam said, "You are violating Assam Accord through this law." Because under Assam Accord, all those who have entered Assam on or after 25th March 1971, those are illegal migrants. They will not be settled in Assam. And now you are saying all those who have entered India on or before 31st December 2014. That means migration from 1971 till 2014 is now legalized, stamped by CAA. And that is why Assam was also protesting. But now you would say, but sir, Assam is exempted from Citizenship Act. These illegal migrants will not be made to settle in Assam. No. These migrants who will be given citizenship will not be made to settle in the areas which are under 6th schedule. Yes, Assam is under 6th schedule, but the entire Assam is not under 6th schedule. There are only 3 districts in Assam which are under 6th schedule. What about remaining districts of Assam? These illegal migrants who are now the citizens of India can be made to settle in non-tribal areas of Assam. That is why Assam is protesting. And there is another peculiar thing about the Citizenship Act. This provision was introduced in the Citizenship Act in 1985. This is known as Section 6A of the Citizenship Act. To implement Assam Accord, Section 6 capital A was added to the Citizenship Act in 1985. What was this section? This section was those who have entered Assam before January 1, 1966, they are the citizens of India. Those who have entered Assam between 1966 till 1971, they won't have political rights for 10 years. Those who have entered Assam after 1971, those are to be identified, deported and arrested. This section was mentioned in the Citizenship Amendment Act. And when CAA 2019 was challenged in the court, the Supreme Court said, we will first look at the validity of Section 6 capital A of the Citizenship Act. We will look at CAA 2019, whether it violates fundamental rights, basic structure or not, whether it is arbitrary or not. But first we will look at whether Section 6A is constitutional. Why? Because how can there be 2 rules in the country? What are these 2 rules? We discussed yesterday that there was a cut-off date. What was the cut-off date? July 19, 1948. What is the cut-off date? When we discussed Articles 5 to 10, I told you we don't have to discuss Articles 5 to 10 in great detail, except few things. Article 5 to 10 talks about who are the citizens of India at the time of the commencement of the Constitution. What will happen to those who migrate from India to Pakistan? What will happen to those who migrate from Pakistan to India? What will happen to those who migrate from India to Pakistan but now want to come back? All those who want to come back, they have to come back before July 19, 1948. And if they come back before July 19, 1948, we will give them citizenship. That means the cutoff to apply for Indian citizenship is July 19, 1948. But then what is the cutoff under Section 6A of the Citizenship Act? Cutoff is specifically different for Assam. For Assam, we say those who enter before January 1, 1966. So if for the entire country, the cutoff is 1948, why for Assam it is 1966? Why no political rights for those who enter Assam between 1966 till 1971? Can in one country we have 2 rules where there is one cutoff date for the rest of the country and the other cutoff date for Assam? Because Assam is the only state which has a different cutoff date for citizenship. And now the Supreme Court has said we will first look at the validity of Section 6 capital A of the Citizenship Act, which was enacted in 1985, and then we will look at the validity of CAA 2019, whether CAA 2019 is constitutional or not. Clear? Something else. This CAA has also impacted our foreign policy. How? For example, Mr. Amit Shah, the Home Minister who moved this bill, who introduced this bill, Citizenship Amendment Bill in the Parliament, He was specifically asked, why have you excluded Muslims? He said, Muslims are not persecuted in Pakistan, Afghanistan, Bangladesh. How can you say 3 Islamic countries can persecute their own members? If you can prove to me that Muslims are also persecuted in Pakistan, Afghanistan, and Bangladesh, we will give them citizenship. So on the floor of the parliament, the Union Home Minister of India is saying that Muslims are not persecuted in Pakistan, Afghanistan, and Bangladesh. But in the international forums, we tell the world community that Pakistan is killing its own people. Look at the Balochistan rebellion, where in Balochistan there is a rebellion against Pakistan. They don't want to be part of Pakistan. And we have taken up the cause of Baloch insurgency, Baloch independence struggle, vehemently in international forum. So we tell the world community that Balochs, who are Muslims, are persecuted by Pakistan. So Pakistan is killing its own people. Pakistan is killing Ahmadis. Pakistan is killing Shias. So Pakistan is persecuting its own people. Afghanistani Taliban is persecuting its own people. Afghani Taliban, they are Pashtuns, but they persecute Uzbeks, Tajiks, Hazaras. So in international community, in the international forums, our stand is clear that India is a rogue state. It is persecuting its own people. So there is a conflicting statements coming from India. On the floor of the parliament, the Home Minister is saying Pakistan does not persecute Muslims. If you can prove that Pakistan is persecuting Muslims, we will give them citizenship. But on the international forum, Subramanyam Jaishankar is saying that Pakistan is persecuting Ahmadis, Shias, its own Baloch people. So now it will have a challenge in the international politics. Second, Hazaras of Afghanistan. Taliban has controlled Afghanistan now. Taliban is predominantly made of Pashtuns because in Afghanistan there are different tribes. Pashtuns, Hazaras, Uzbeks, Tajiks, so on and so forth. So Taliban is predominantly made of Pashtuns. But they also persecute other religious communities, other ethnic communities. For example, Hazaras. And Hazaras have been supporting India for a long time against Taliban. So we have cultivated a group, a support group in Afghanistan who support India. For example, 1999, IC-814, an Indian Airlines plane was hijacked. It first went to Dubai for refueling, and then this plane landed in Kandahar, which was then the capital of Taliban-controlled Afghanistan. And then the terrorists were negotiating with India. The terrorists said, give us 3 people. In return of these 3 terrorists, we will release all the hostages. One terrorist who was released was Masood Azhar. Once he was released, he went to Pakistan and he started Jaish-e-Mohammed, a terror organization, which was responsible for the parliament attack of 2001, which was responsible for the Uri attack, which was responsible for the Pathankot attack, which was responsible for the Pulwama attack. Then we released one more guy, Mushtaq Zargar. We released another, and Mushtaq Zargar later on founded another terror organization, Al-Umar Mujahideen in Pakistan. Then we released another person, Umar Sharif, on whose life Omerta movie was made by Rajkumar Rao. Hansal Mehta was the director, if you know him. So we have had strained relations with Afghanistani Taliban. And for years till 2001, when Taliban was controlling Afghanistan, we did not have good relations with Afghanistan. But once Taliban was thrown out, America launched its war on terror. And in Afghanistan, Taliban was routed, Taliban was dissolved. Then the civilian governments which started in Afghanistan, India and Afghanistan started having great, beautiful relationship. And that is how even the parliament of Afghanistan was constructed by India. Mr. Modi was responsible for inaugurating that parliament house. And when that Parliament House was inaugurated, Mr. Modi quoted a famous song of Bollywood movie, I think that is Zanjeer, starring Pran and Amitabh Bachchan as the angry young man, wherein Mr. Modi said, Yari hai iman mera, yar meri zindagi. So we are friends, we are dost. Because in Zanjeer movie, Pran, who was playing the role of a Pathan, he was a friend of Amitabh Bachchan. Initially an enemy, later on became a friend. So we are now developing friendship. So we have cultivated friendship in Assam, in Afghanistan. But now we are telling Afghans that you persecute your own religious minorities. So it will have a foreign policy challenge. And there is one bright spot in India's foreign policy, which is Bangladesh. Look at our neighborhood. Nepal, now we have a communist government in Nepal. And Nepal is as if it is in the lap of China. Myanmar is in the lap of China. Sri Lanka is in the lap of China. Pakistan was already in the lap of China. If there was one in Maldives, various other countries in our neighborhood, we gave 2 helicopters to Maldives. Then they had a new president, Ibrahim Saleh, who said, we don't need these helicopters, take them back. We are friends with China. So in our neighborhood, we have seen hostile neighbors. And we have seen the grip of China over our neighbors. But one shining spot was Bangladesh, where some of the terrorists which were wanted in India, they were sent by Bangladesh to us. They were extradited from Bangladesh to us. So Bangladesh, under the current Prime Minister Sheikh Hasina, has been a strong ally of India. But then when CAA was passed, there were few ministers from Bangladesh who had to come to India. They cancelled their visit. The finance minister of Bangladesh, the foreign affairs minister of Bangladesh, they cancelled the visit, saying on one hand, you are extending the hand of friendship. And on the other hand, you're telling your people that Bangladeshi illegal migrants are in Assam. So Bangladeshis are infiltrators. And at the same time, we are persecuting our religious minorities. So this CAA passing has also impacted our foreign policy. But be that as it may, this is CAA 2019, arguments in favor, arguments against. One more argument against is OCI. There were 5 grounds on the basis of which the OCI card could be cancelled. 6th ground was added in 2019. The 6th ground said if the OCI violates any law that is in force in the country. Any law means 2 wide powers are given to the government. Anybody, any OCI card holder who is basically criticizing the government, maybe, but he is driving a car without any license, his OCI card can be cancelled. That means 2 wide powers have been given to the center. 2 wide powers which can also be misused, because more the powers, more liability of misuse as well. You could have simply mentioned that if you violate national security, your OCI card could be cancelled. If you indulge in terrorism, your OCI card could be cancelled. If you violate public order, your OCI card could be cancelled. You can't give such a wide power to the central government that if an OCI violates any law that is in force in this country, your OCI card could be cancelled. Giving such wide powers is also anti-democratic. If you have any questions, please let me know. Then we will shift to NRC and CAA. Is CAA 2019 applicable to Afghanistan's and Bangladeshis? In a sense? Akula, can you please elaborate your question? Any question, please let me know. What is that massive movement name? Assam agitation. Is there any logic giving OCI cards? Does it benefit India? Yes, it does benefit. One, we ensure that they still have links with India. They send remittances from foreign countries to their family or their relatives in India. They will also persuade their governments now to have good relations with India. For example, Indo-US nuclear deal, when it was signed in 2008, one of the individuals who was instrumental, who played a very important role in signing this Indo-US nuclear deal, the name was Sant Singh Chathwal. He is a hotelier in United States, very close to the Clintons. And ultimately, Hillary Clinton was the Secretary of State when very important role was played by Sant Singh Chathwal. What is the final verdict of the Supreme Court? The final verdict is yet to come. Why Rohingyas not given citizenship? Because they are not eligible according to the government. Sir, I am asking, is under CAA citizenship given or OCI cards? Under CAA 2019, citizenship will be given to those who come from Pakistan, Afghanistan, Bangladesh, belonging to these religious communities. But under Citizenship Act in 2005, OCI scheme was launched. Originally, there were 5 grounds on the basis of which your OCI card could be cancelled. Now, CA 2019 introduces a 6th ground on the basis of which your OCI card could be cancelled. Is CAA now applicable in India? Now, CAA is a law. This law is passed by the legislature, which is the parliament. Now, to implement this law, we need rules. And rules will be made by the executive. Executive in the sense, how can we be sure? Because Parliament is passing a broad law. Parliament will not go into too deep nitty-gritties. Parliament will pass a broad law. The broad law is Pakistan, Afghanistan, Bangladesh, 3 countries. There are 6 religious minorities. If you have come to India on or before 31st December 2014, you're eligible for citizenship through naturalization. And for you, the period of naturalization is reduced from 11 to 5 years. That's it. The law is over. But how can we prove? How can we be sure that this individual has come from Pakistan, Afghanistan, and Bangladesh? What are the documents required for that to prove that you have come from these 3 countries? For that, we need rules. Similarly, how can we be sure that you are from Hindus, Christians, Sikhs, Buddhists, Jains, Parsis, and you're not Jews, you're not atheists, you're not Muslims? For that, there have to be rules. How can we prove, how can we be sure that you have entered India on or before 31st December 2014? What are the documents that you have to furnish to prove your claim that you have entered India before 2014? For that, we need rules. And these rules will be passed by the executive, which means the Ministry of Home Affairs, which means the bureaucrats of the Ministry of Home Affairs will make these rules to implement Citizenship Amendment Act. But these rules have not been made. Why? Because the law was passed in 2019 and COVID-19 struck India in 2020. And then extension after extension was sought. What is that extension? Rules say whenever the law is passed by the parliament and signed by the president, within 6 months, rules should be made by the executive to implement such a law. Whenever a law is passed by the parliament, signed by the President of India, the moment President signs this law, next 6 months, within 6 months, executive should make rules to implement this law. And if you cannot make rules within 6 months, then you have to seek extension from the Committee on Subordinate Legislation. What does that mean? Law has been passed by the parliament, legislature. Is that clear? Very good. Rules will be made by whom? Executive. That means the bureaucrats. But are bureaucrats making good rules or bad ones? Are bureaucrats making rules which are within the limits of the law, or they are violating the law? Whether there are some rules which are horrible. That means legislature should also keep a check on these rules. Legislature should also identify whether these rules are good, bad, ugly, beautiful or not, whether they are legal or not, illegal or not, whether they are within their powers to make such a law. For example, here we tell executive under CAA, you make rules to implement this law. For example, make rules so that we can be satisfied that these people have come from Pakistan, Afghanistan, Bangladesh. Make rules so that we can satisfy these belong to the 6 religious minorities. We have not given executive the power that you can impose tax. What if under these rules, executive starts imposing tax? But that is not the power. So legislature should also keep a check on these rules. There is one committee specifically created to keep a check on these rules, and that committee is known as Committee on Subordinate Legislation. It will have 15 members. 15 members of Lok Sabha. In Lok Sabha, we will have this committee. In Rajya Sabha, we will have 15 members, part of this committee. This committee will keep a check on these rules. Whenever executive will make these rules will be presented to Committee on Subordinate Legislation. Dear parliamentary committee, we have made these rules. Could you please take a look at them? And this Committee on Subordinate Legislation will keep a check whether these rules are good or bad, whether these rules make some additional grounds which are not provided in the law. The law says if within 6 months of the signing of this law by the president, if the rules are not made by the executive, then the government will have to seek extension from cabinet, from the Committee on Subordinate Legislation. First time Home Ministry approached this Committee on Subordinate Legislation. See, because of COVID, we are not able to make rules. Give us extension. I said, okay. Because of COVID, we are not able to make rules. Another extension. Because of COVID, we are not able to make rules. Another extension. Because of COVID, we are not able to make rules. Another extension. Because of COVID, there is no COVID, but we are not able to make rules. Give us extension. Okay. Because of COVID, there is no COVID, but we are unable to make rules. Another extension. And 7th extension was given recently to the government, to the executive, to make these rules to implement Citizenship Amendment Act. So as of now, the law is passed, but it has not been implemented. Could we criticize our government as UPSC aspirants, especially in mains? You can criticize, but criticism should be logical. It should not be, don't make sweeping statements. This government is communal. Don't do that. This government is corrupt. Don't do that. I don't like Modi ji. Don't do that. Because the examiner would be a lover of Mr. Modi, you're gone. Write arguments which are legal. Write arguments which are justifiable. So you can write arguments such as quoting Justice Malhotra, inner judgment infused Article 15 grounds into Article 14. She interpreted intelligible differentia to be reasonable differentia. She required intelligible differentia to fulfill 2 subsets. One, there must be a yardstick to differentiate between those included and those excluded, and that yardstick must be reasonable. That means, yes, you have to use some criteria to include some, to exclude some. But this criteria should itself be reasonable. And this criteria cannot be the core intrinsic trait of an individual. One core intrinsic trait of an individual is religion. So religion cannot be used to differentiate between 2 sets of people. Quote her, quote Faizan Mustafa, quote Pratap Bhanu Mehta, quote others, but don't make your own value-based judgments. Okay, done? Perfect. Now here is NRC, here is CAA, and here is NPR. What is NRC? National Register of Citizens. What is CAA? Citizenship Amendment Act. You know that. I'll still write it. And what is NPR? National Population Register. Okay. NRC, what does it detail? It contains details of Indian citizens. Clear? What does CAA say? If you are from Pakistan, Afghanistan, and Bangladesh, but you are Hindus, Christians, Sikhs, Buddhists, Jains, Parsis, which basically means you are eligible for citizenship. Clear? And then National Population Register details all the usual residents of India. Who are the usual residents of India? I told you about NRI. All those who are residing in India for more than 182 days, they become residents of India. Those who stay in India for less than 182 days, they are non-resident Indians. So who are these usual residents of India? All those who can be citizens, all those who are foreigners as well. But who are these people? Who stay in India or who want to stay in India for 6 months, which means 182 days. These are the three things: NRC, CAA, National Population Register. For example, census, when it is carried out every 10 years, we look at the population of this country. What is the entire population of India? Clear? But what about people who have migrated to other country, or people who have migrated to a different state, or people who are not regular in India, who are not resident of India? We need schemes which can specifically target migrants, for example. For that, we should know that if this is Bihar, this is the population of Bihar, but the majority of the population is migrated to Rajasthan or Uttar Pradesh or Maharashtra or Karnataka, so that we can specifically target those who are the migrants. For that, we need National Population Register. And this National Population Register started when UPA was in power in 2010. It was updated in the year 2015. It was to be updated in 2021. Didn't happen because of the COVID pandemic, but what is the implication? Mr. Amit Shah, when CAA was being debated, when NRC was being carried out in Assam, Mr. Amit Shah gave a statement which is considered to be a controversial statement, and that is why there were people who were protesting. He said, look at the chronology. First, we will pass CAA, then we will implement NRC in the entire country. NRC not only in Assam, we will implement NRC in the entire country. And we will re-implement NRC in Assam. Why? Why not? We'll discuss. Then there were protesters who were protesting against CAA, and particularly there were Muslims who were protesting. Now, why were Muslims protesting? Muslims, according to various authors, they were not protesting because they wanted Muslims from other countries to also become citizens. So they are not concerned with CAA individually. CAA deals with foreigners from Pakistan, Afghanistan, Bangladesh. They can come to India, we will give them citizenship. So these protesters are not concerned about foreigners. They are concerned about themselves. Themselves how? When you mix CAA with the NRC. How do you mix it? If Mr. Amit Shah says, we will implement NRC in the entire country. NRC was implemented in Assam. How many individuals failed to prove their Indian citizenship? 19 lakhs. So in one state, 19 lakhs failed to prove their citizenship. It may be possible that some of them were genuinely Indian citizens, but they don't have documentary proof. They don't have documentary evidence. You may not be literate. That means you don't have a school certificate. Your family may not have the birth certificate, or you had birth certificate as well. But because of the tsunami, because of the earthquake, because of the floods, because of the communal violence, because of any other atrocity, you have lost your documents. Now you can't prove that you are the citizens of India. Which means it is easier for educated, wealthy, or not so wealthy people to prove their citizenship because they have the documentary evidence. But nomads, migrants within the country who migrate from Bihar to Punjab, from Punjab to Karnataka, they may not be having educational qualification, they may not be having certificates, they may have lost their all documents in fire, in tsunami, in earthquake, in hurricane, whatever it is. How can they prove their citizenship? So if 19 lakhs could not prove their citizenship in Assam, when NRC was implemented in Assam, if NRC is implemented in the entire country, let's say this 19 lakhs becomes 199 lakhs, or it becomes 1000 lakhs. Now these 1000 lakhs are unable to prove their citizenship. When these 1000 lakh people are unable to prove their citizenship, but these people will be fed to a filter. And this filter is known as Citizenship Amendment Act. So these 1000 lakh people, when they have failed to prove their citizenship, these can be Hindus, Christians, Buddhists, Jains, Parsis, anybody. But once they are fed to this filter called CAA 2019, which means from this filter, we will filter out Hindus, Christians, Buddhists, Jains, Parsis and Sikhs. We can tell them that you have come to India from Pakistan, Afghanistan, Bangladesh. Now you are eligible for citizenship. Once you are eligible for citizenship, your name will be mentioned in the NRC. That means the only community which will be left will be the Muslims. That is why critics say that people are protesting not only against CAA, they are protesting against the double combine of NRC plus the CAA. So if NRC is implemented in the entire country, and then there are lakhs of people who fail to prove their citizenship, all those who are non-Muslims will be saved by CAA 2019. They will be given citizenship. And the only ones which will be left out will be Muslims. So this is an idea to disenfranchise Muslims. That's why they are protesting. But NRC has not been implemented. CAA has not been implemented. So let's keep them aside. This NPR again became a sticking point, again became a political point. When NRC was conducted in 2010, details were sought under NPR, such as what is your name, where are you residing in this place for 6 months or more than 6 months or less than 6 months. These details were sought. But when in 2021, this NPR was to be updated again. This time the government said we need details such as what is your place of birth, what is your year of birth, what is your Aadhaar, what is the place of birth of parents. These details were not included in 2010. These details were not sought from the people in 2010. But these details were specifically asked in 2021. And that is how states such as Andhra Pradesh said, we will not implement NPR. Telangana said, we will not implement NPR. Bihar said, we will not implement NPR. Other states, West Bengal said, we will not implement NPR. Kerala said, we will not implement NPR. Why? Because they allege that NPR is nothing, but it is NRC. How? Till 1987, whoever is born on the soil of India automatically becomes the citizen of India. Right or wrong? Right. How can we know through NPR whether you are Indians or not? By year of birth. That means if your year of birth is 1987, we will not touch you, you are the citizen of India. But if your year of birth is after 1987, tell us what is the place of birth of your parent. When you will tell us what is the place of birth of your parent, because after 1987, one of the parent has to be an Indian. After 2003, other parent should not be an illegal migrant. That means when you are seeking these details, what is the place of birth of your parents? If the place of birth is India, then you are Indian. If the place of birth is outside India, then you are not an Indian. Which means people said this NPR is nothing, but it is NRC in disguise. Because Mr. Modi, the Prime Minister, had said that we have never discussed NRC. We are not going to implement NRC yet. But then the government said we will have NPR, and this time more details will be sought. And political parties said the government is not implementing NPR. The government is basically implementing NRC. Because by seeking details such as what is your place of birth, what is your year of birth, what is the place of birth of your parents, you are basically segregating NPR into citizens and foreigners or illegal migrants. That is why people protested. But even this NPR could not be implemented because of the COVID-19 pandemic. So NRC not implemented, only implemented in Assam. CAA, although the law is passed, but rules have not been made, and NPR has not been implemented yet in its new form because of the pandemic. That completes our discussion on citizenship. Any questions, please let me know. Then we will jump to fundamental rights. Sir, is it 182 days or 120 days to be considered as a resident? 182 days to be a resident, but whether you have to pay tax or not, if your income from India is less than 15 lakhs, then if you stay in India for less than 182 days, you are a non-resident Indian. But if your income from India is more than 15 lakhs, then if you stay in India for less than 120 days, you are a non-resident Indian. I will give you a break, don't worry. Sir, currently NRC is only for Assam or NPR. NRC has been implemented in Assam. Okay, so let's take a break. Let's meet 7:45 and then we will start a discussion on fundamental rights. See you on the other side of the break. Shall we continue? Okay. So what have we discussed till now? In the first class, we discussed what is a constitution, then what is a unitary and federal constitution, theory of separation of powers, along with doctrine of checks and balances, what is constitutionalism, and then we looked at various kinds of majorities that we will encounter in the Indian Constitution. Then we jumped to preamble, we the people of India, and we looked at what is the significance of preamble. Then we looked at part 1 of the Constitution and we discussed articles 1 to 4. Then citizenship, where part 2 of the Constitution deals with articles 5 to 11. But more specifically, we focused on article 11 of the Constitution. And we discussed Citizenship Act of 1955. What are the ways by which one can acquire citizenship, lose citizenship? And we discussed and elaborated on the CAA 2019, whether it is good or bad, without any bias, without favoring one argument as against the other. So it's our objective, our endeavor to tell you both sides of the story without you realizing on which side I am. So I did not tell you what is my take on CAA. That's not required for this examination. What is required, you should know the arguments in favor of CAA, arguments against CAA, strictly according to the requirement of this exam. Nothing more, nothing less. Done? Now we will jump to one of the most important parts of the Constitution, not only relevant for your exam, but as citizens, you should also be aware of what are the rights that are given to you by the Constitution. And here we will discuss part 3 of the Constitution, known as fundamental rights. And this chapter deals with articles 12 to 35. Do you have to remember and memorize all these articles? No. But are there articles which you must remember, memorize? Yes. Which are these articles? I will tell you one by one. Clear? But what is fundamental right, basically? In layman's terminology, how can we understand what is a fundamental right? For example, you have to construct a building. To construct a building, you need some important ingredients. For example, you need cement. For example, you need steel. For example, you need labor. Without these ingredients, can you establish and construct this building? No, not possible. Similarly, as an individual, if you want to grow, if you want to explore your potential, all of us have one or the other talent. You may be more talented than me. A may be more talented than C, but we all have talent. How do we explore this talent and ultimately grow as an individual? For that, we need some ingredients. Those ingredients are rights. And those ingredients are what we call fundamental rights. For example, I want to explore my potential. I want to grow as an individual. First, I need equality. Equality in the sense, I can teach good, but there are other individuals also who can also teach. But the state, the government is telling me, because of your religion, because of your caste, because of your gender, you cannot teach, others can teach. That means you're denying me equality. You're discriminating against me. If I am not given right to equality, can I grow as an individual? No. If I'm not given freedom to choose my profession, can I grow as an individual? No. If I'm discriminated, can I grow as an individual? No. All these are important ingredients for the growth and development of an individual. What are these rights that are so important for the growth and development of an individual? Without these rights, you cannot explore your potential. Those rights, those basic rights are known as fundamental rights. But these fundamental rights should also be guaranteed. Guaranteed in the sense, I have to construct a building. For that, I need cement, I need labor, I need steel, I need road blocks, for example, whatever it is. You are told, okay, take cement, take steel, take labor, but we will not guarantee you. Guarantee in the sense, we cannot guarantee cement. Can I construct a building? No. We cannot guarantee you steel. Can I construct a building? No. That means although you are told that you can construct a building, without being guaranteed the ingredients which are required to construct that building, then how can I construct the building? You are saying construct the building, but you are not providing me with the ingredients. How is that possible? Similarly, these rights should be guaranteed by the Constitution. Because if it is left to the government can today give you equality, tomorrow snatch it. Government can today give you freedom, tomorrow snatch it. Government can today give you employment, tomorrow snatch it. But there should be these rights which are basic, necessary for the growth, development of an individual. These rights should be guaranteed by the Constitution so that no power on earth can snatch these rights from you. So those rights which are fundamental for the growth, development of an individual and are guaranteed by the Constitution, those rights are what we call fundamental rights. This is just layman's idea about fundamental rights. But now, let's get to the heart of it. When we look at three parts of the Constitution, which are these three parts? Part 3 deals with fundamental rights. Part 4 deals with directive principles of state policy. Part 4, capital A, deals with fundamental duties. Although these three parts are separate in the sense, part 3 deals with fundamental rights, part 4 deals with directive principles of state policy, part 4, capital A, deals with fundamental duties. Although these are three separate, distinct parts, yet what do? They come together and they give shape, they concretize the lofty goals that are mentioned in the preamble. So if preamble has some objectives for the Constitution, if preamble talks about some of the objectives of the Constitution, such as justice, such as liberty, such as equality, such as fraternity, such as dignity of an individual, all these objectives of the Constitution are implemented, are given shape, are concretized through these three parts of the Constitution. Part 3, Part 4, Part 4, capital A. And in political theories, we call all these parts into negative obligations, positive obligations, and duties. Negative obligations are fundamental rights. Positive obligations are directive principles of state policy. Duties are fundamental duties. What are these negative obligations? Listen to me carefully. Whenever we look at these fundamental rights, which we will discuss today onwards, you will encounter that these fundamental rights, their sense is negative. Negative in the sense, the state shall not deny equality before law and equal protection of the laws. The state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this, the state shall not do that. That means these fundamental rights are basically limitations on the powers of the state. Powers of the states are not unlimited. There is a limitation on the powers available with the state. Don't deny equality. Don't discriminate. Don't discriminate when it comes to government jobs. Don't deny an individual of his right to life and personal liberty. Don't do this, don't do that. That means the Constitution, under Part 3 of the Constitution, is imposing negative obligations on the state. That state, do not discriminate, do not deny equality, do not violate privacy, do not interfere with the life and liberty of an individual. So what are these fundamental rights? These implement doctrine of limited government, where the powers of the government are not unlimited. There is a limitation. One such limitation is fundamental rights. Don't discriminate. Don't deny equality. Don't violate right to life and personal liberty. Don't deny privacy. So negative obligations are imposed on the state. Do not interfere with the liberty of an individual. Don't interfere. But when it comes to directive principles of the state policy, we call them positive obligations. In a sense, in fundamental rights, we are telling the state, don't interfere with the equality, don't discriminate, don't interfere with the life and liberty of an individual. But directive principles, there we tell the state, please interfere. Please interfere so that we can establish a welfare state. Please interfere so that this wide gulf between the rich and the poor can be minimized. Please interfere so that we can provide good, nutritious food to the people. Please interfere so that we can improve the standard of living of the people. Please interfere so that we can establish Panchayati Raj institutions in India. Please interfere so that we can implement a uniform civil code in India. Please interfere so that we can separate executive from judiciary. Please interfere so that rich should not become richer and poor remain poorer. We should bridge the gap between the two. Please interfere. That is why when you look at directive principles of state policy, there the wording is, the state shall organize village panchayats. The state shall enact a uniform civil code. The state shall do this. The state shall do that. That means in directive principles, the wording is positive. We are asking the state, please interfere so that you can improve the standard of living of the people. And in fundamental duties, we make citizens responsible. I, as a citizen, I have a duty towards the state. I have a duty towards my environment. I have a duty towards the forest, the wildlife. I have duties towards my fellow human beings. How can the Constitution of India make the citizens of India as responsible citizens so that we can establish fraternity, a sense of common brotherhood amongst all the members of the society? That is what we call fundamental duty. So although these are three different separate units, separate parts of the Constitution, Part 3, Part 4, Part 4 capital A, yet they come together to do what? To implement. Implement what? Those lofty goals that are mentioned in the preamble to the Constitution, which is justice, which is liberty, which is equality, which is fraternity, which is dignity of an individual. And in political science, we can break them into negative obligations, fundamental rights, positive obligations, directive principles of state policy, fundamental duties to make citizens responsible citizens so that we can implement a sense of the objective of fraternity. We will look at first fundamental rights, then we will jump to directive principles of state policy, and after that we will look at fundamental duties. But what are these fundamental rights? Democracy can be either social, economic, political. As a society, there are different communities residing in India. SCs, STs, OBCs, economically weaker sections of the society, and the others. To provide something more to SCs, STs, OBCs, because these communities have been socially discriminated against in the past. For that, we have directive principles of state policy. Economic democracy. For example, the rich and the poor. This gulf, this distance between the two should be minimized. Whatever economic system we use, whether it is socialism, whether it is capitalism, whether it is communism, whatever economic system we use, This economic system should not result in the concentration of wealth in fewer individuals. That means rich are becoming richer, the poor are remaining poorer. This cannot happen. How do we ensure that this does not happen? Through directive principles of state policy. So directive principles of state policy are meant to promote social and economic democracy. But to implement political democracy, to promote the idea of political democracy, we have fundamental rights. And if we implement political democracy, it prevents the establishment of an authoritarian or despotic rule. What is this authoritarian rule? I'm trying to the best of my capability to teach you to the best of my knowledge to make it simple, interesting for you. Suddenly the police comes and arrests me. If I have no fundamental right, the police can throw me in the dustbin of the jail forever and ever, and I will never see the light of the day. Should this be allowed? No. Who protects this and prevents this from happening? Fundamental rights. So fundamental rights are meant for promoting the ideal of political democracy. Because if there are no fundamental rights, then we will result in a despotic rule, an authoritarian rule, just like North Korea. There's a meme going on, was going on when COVID-19 struck the world, that in North Korea, there are no cases of COVID-19. Why? Because whenever somebody tests COVID positive, he is shot dead. Nobody can question Kim Jong-un. Why? Because he's an authoritarian leader. There are no rights for the people. Communist China, no rights. The founder of Alibaba, for a long time was hiding because the communist state, the Chinese state, will arrest him or will do something to him. That means in despotic regimes, in authoritarian regimes, there are no rights. But once there are rights enshrined in the constitution, guaranteed by the constitution, what does it prevent? It prevents the establishment of an authoritarian regime. And for the establishment, for promoting political democracy, we have fundamental rights. But for promoting social democracy, economic democracy, we have directive principles of state policy. And these fundamental rights operate as limitations. Limitations in the sense, executive cannot violate these fundamental rights, nor can the legislature violate these fundamental rights. These rights are so important, so sacred, so fundamental for the growth of an individual, guaranteed by the constitution. But how can we guarantee that neither the executive nor the legislature can violate these fundamental rights? So these fundamental rights operate as limitations on the executive as well as the legislature. And in short, they aim at establishing a government of laws and not government of men. What is the difference? If I am a dictator, I am the judge, jury, and the executioner. Today I can pass a law. And what is that law? Whatever I say is the law. Whoever I want to be arrested can be arrested. Whoever I want to be hanged can be hanged. This is government of men, and men can make mistakes. But if you want government run by the law, because if the law says you cannot arrest somebody without committing a crime, you cannot kill somebody without judiciary saying he is guilty, you cannot hang somebody without the Supreme Court saying you are guilty, you hang by your neck till death. So it is not you who can hang me, it is the judiciary order which can hang me. Separation of powers. So political democracy and these fundamental rights, they basically aim at establishing government of laws, not government of men. So long story short, what are these fundamental rights? Fundamental rights are for promoting the ideal of political democracy. They act as limitations on the powers of the executive and the legislature. And in short, they help in establishing the government of laws and not government of men. Clear? Something else. What are these rights? Rights are basically claims. What is a claim? You have the right to ask me questions. Why? Because you have paid fee. When you have paid fee, you have the right to ask me questions. So you can claim that I have to ask you questions. That's my claim. Please answer this question. Why? Because that's your right. Similarly, these rights, these claims can be broadly classified, categorized into two big categories, two broad categories. One are constitutional rights, the other statutory rights. What is a constitutional right? A right which is guaranteed by the Constitution, which you can claim, which is mentioned in the Constitution. Those rights are what we call constitutional rights. But there are other rights which are not mentioned in the Constitution, but which are mentioned in statutes. Statutes means a law. Which law? Which is passed by legislature. Legislature means the parliament. All those rights which are not mentioned in the Constitution, but are given to you by the legislature, given to you by the parliament, given to you by various statutes, those are what we call statutory rights. For example, MG Narega, Mahatma Gandhi National Rural Employment Guarantee Act. This is an act of the parliament. It gives you a right. What is the right? If you are from rural India, you belong to below poverty line family, you have a right that for 100 days I have to give you employment. I'm the state, I have to give you employment. And if I cannot give you employment, I have to give you unemployment allowance. This is a right, which means you can claim it from the state. But this is the right to employment under Manrega. This is the right which is not given by the Constitution. This is the right which is given by the law passed by the parliament. So MG Narega becomes your statutory right. You have the property. You can transfer this property to someone else in someone else's name. This is the right which is not given to you by the Constitution. This is the right given to you by the law passed by the parliament. It becomes a statutory right. Right to information. For example, there is a public body. Which public body? A government body. Which government body? Let's say, for example, a municipality. How this municipality is spending money, how this municipality is taking decisions, how this municipality is arriving at decisions, all this information can be sought by you. That is what we call sunlight is the best disinfectant. Sunlight is the best disinfectant. What does that mean? Whenever there is a transparency in working of an institution, corruption would be less. So if this municipality is given 10 crore rupees to spend, if nobody comes to know how this money has been spent, what will the municipal commissioner do? Pocket 5 crores in his pocket, give 2 crores to other officers, give 1 crore to a politician, give 1 crore to a judge. Nobody would come to know where this money has gone. But if there is transparency, if you have the right to ask question to this commissioner, where have you spent this 10 crore rupees? He has to answer you because you had the right to information. So when I know as an officer that people can ask me these questions, where have I spent this money? I will not indulge in corruption. Why? Because otherwise people will come to know. Right to information is your right, but guaranteed not by the Constitution, because it's not mentioned in the Constitution. It is a law passed by the parliament known as RTI Act of 2005, Right to Information Act 2005. So what are rights? Rights are basically claims. Claims from the state. You can claim something from the state. Now these rights can be broadly categorized into two. Either these rights are constitutional rights, that means those rights which are mentioned in the Constitution, or these rights are given to you by the law passed by the parliament, by the legislature. Those laws which are passed by the legislature, if they give right to you, then those rights are what we call statutory rights. But within constitutional rights, there can be two broad rights. Either you can have fundamental rights, which are mentioned under Part 3 of the Constitution, or you have other constitutional rights. What is other constitutional rights? If there are rights which are mentioned in the Constitution, but Constitution has 25 parts, those rights which are given under Part 3 of the Constitution, they are called fundamental rights. Those rights which are given by the Constitution, but not under Part 3, but by other parts of the Constitution, those we call other constitutional rights. Which are these other constitutional rights? For example, the right to vote. All the citizens of India, if you have completed 18 years of age, you have the right to vote. That means you can claim vote. This claim is mentioned where? In the Constitution, but under Article 326 of the Constitution. This is not a fundamental right because it is not mentioned under Part 3 of the Constitution. Similarly, the right to start or have interstate business, trade and commerce. That means if you are from Karnataka, but you have the right to have business operations in other states as well. You have the right to transport your business from one state to another, transport your goods from one state to another, transport services from one state to another. That's your right. But this right is not under Part 3 of the Constitution. So this is not a fundamental right. It is other constitutional right under Article 301. Similarly, right to property. Right to transfer property is given by the law. But right to acquire property, and if the state wants to acquire this property, state has to give you compensation. This right to property is other constitutional right mentioned under Article 300 capital A. Long story short, we are discussing fundamental rights. Fundamental rights, Part 3 of the Constitution, dealing with Articles 12 to 35. Clear? What are these fundamental rights? We have to look at fundamental rights under Part 3, directive principles under Part 4, fundamental duties under Part 4 capital A. Although these are separate parts, although these are separate units, but when we look at them together, what do they try to do? They try to implement the objectives mentioned in the preamble, which is of justice, which is of liberty, which is of equality, which is of fraternity, which is of dignity of an individual. We will first look at fundamental rights, then DPSP, then fundamental duties. What are these fundamental rights basically? So important rights that without the growth of an individual, without these rights, growth of an individual is not possible. Those are what we call fundamental rights. And these fundamental rights are aimed at promoting political democracy. These act as limitations on the executive and the legislature. These ensure that we implement the government of law, not government by men. Right basically is a claim, something you can claim. There are rights which are mentioned in the Constitution, known as constitutional rights. There are rights which are not mentioned in the Constitution, but given by the Parliament, given by the legislature. Those are what we call statutory rights. But those rights which are mentioned in the Constitution can further be divided into two groups. Either the rights are fundamental, which means those mentioned under Part 3 of the Constitution, or the rights are mentioned in other parts of the Constitution, other than Part 3 of the Constitution. Those are what we call other constitutional rights. And which are these rights mentioned under Part 3 of the Constitution? 6 set of fundamental rights. Right to equality is a fundamental right under Part 3. Right to freedom, right against exploitation, right to religion, right cultural rights, educational rights, right to constitutional remedies. Don't write it down yet. I'll discuss all of them one by one. But there are 6 set of fundamental rights which are mentioned under Part 3 of the Constitution. And these are so important fundamental rights that if the state is violating them, you can directly approach the Supreme Court. What's the difference? What's the difference between other constitutional rights, fundamental rights, and statutory rights? If other constitutional rights are violated, you can approach the High Court. Then you can approach the Supreme Court. If the statutory rights are violated, first you can approach the High Court of a state. Then you can approach the Supreme Court. But fundamental rights are so important for the growth and development of an individual. And these are guaranteed by the Constitution. And the Constitution has guaranteed these fundamental rights by making Supreme Court as the guardian of your fundamental rights. So if your fundamental rights are violated, directly knock the doors of the Supreme Court. Supreme Court will protect your fundamental rights, uphold your fundamental rights, because these fundamental rights are guaranteed by the Constitution, and Supreme Court has been made the guardian of your fundamental rights. One more thing. All fundamental rights are legal rights. But reverse is not true. All fundamental rights are legal rights, but all legal rights are not fundamental rights. How? Look at me carefully. What is a legal right? What is a legal right? Right given by law. If the law is giving you a right, it becomes a legal right. Now, this law can be a supreme law of land or an ordinary law of land. Clear? What is supreme law of land? Constitution. What is ordinary law of land? The law passed by the legislature. And within Constitution, there can be fundamental rights. Within Constitution, there can be other constitutional rights. So when we say, are fundamental rights legal rights? Yes. Why? Because they are provided by the law. Which law? The supreme law of land. Which law? Constitution. So are fundamental rights legal rights? Yes, because they are provided by the law, which is the supreme law of land, which is the Constitution. But are all legal rights fundamental rights? No. Because a legal right can be the right given by the legislature. For example, right to information. Is right to information a right? Yes. Is it a legal right? Yes. But is it given by the supreme law of land or ordinary law of land? Ordinary law of land. That means all legal rights. Legal rights can be fundamental rights, other constitutional rights, statutory rights. So all legal rights cannot be fundamental rights. Only those rights which are under Part 3 of the Constitution, they are fundamental rights. So basically all fundamental rights are legal rights. But reverse is not true. All legal rights are not fundamental rights. Is that clear? According to Supreme Court, right to vote is a legal right. According to UPSC, the exam that you have to give, right to vote is a constitutional right. Any questions as of now? Yes, no, maybe. Shall we continue? Okay. Now let's look at the global picture of these fundamental rights. We will compare these fundamental rights, the existence, the status of these fundamental rights in two other democracies, England and the United States of America, and compare them with India. Why? Because United States is considered to be the oldest federal constitution of the world, correct? Yes. England is a country from which we have derived a lot of roles, responsibilities. In a sense, Prime Minister in India, Prime Minister in UK, they have similar power. Speaker of Lok Sabha, Speaker of the Legislature in UK, they have similar power. That means we have borrowed the same parliamentary form of democracy that is existing in United Kingdom, in Britain. The same constitutional parliamentary democracy we have found in India as well. We have implemented in India. That is why it is always important to compare India with US, because it's the oldest federal constitution and we claim we are the federal constitution, and United Kingdom or England, from where we have derived a lot of constitutional practices. In England, there is no code of fundamental rights. There is no such thing as fundamental rights. Then what does that mean? That means the foundation of individual rights in England may be said to be negative. Negative in the sense, listen to me carefully. What are the fundamental rights available to us as Indians? Right to equality, right to freedom, right against exploitation. That means there is a clear-cut list of fundamental rights which are available to us under the Constitution. Similarly, United States also, they have something called Bill of Rights, where all the fundamental rights that are given to the people of United States are mentioned. Apart from these, which are mentioned in the Constitution, do we have other fundamental rights? No. That means, do we have right to vote as a fundamental right? No. Do we have right to property as a fundamental right? No. Do we have right to information as a fundamental right? No. Do we have right to employment under MG Narega as a fundamental right? No. In England, there is no such thing as fundamental right, which means in England, you can do anything that you want to do, everything that you want to do, except those things which are prohibited by the law passed by the British Parliament. In a sense, British Parliament passes a law, don't commit murder. Right to commit murder will not become your right, because it has been expressly prohibited by the British Parliament. Don't commit murder. Don't rape. So right to rape cannot become your fundamental right. Don't commit corruption. So right to corruption cannot become your fundamental right. Is there a British law which says don't marry? Right to marry is your fundamental right. Is there a British law which says you can't have same-sex marriage? Same-sex marriage is your fundamental right. Is there any law in Britain which says you can't say whatever you want to say, you can't express yourself, you can't have freedom of speech and expression? Freedom of speech and expression is your fundamental right. So what are you trying to say? I am saying in Britain there is no such thing as fundamental right, or there is no code of fundamental rights. In a sense, there is no list that this is the list of fundamental rights. Then what are the fundamental rights available to people in Britain? All that you want to do is your right. Everything that you want to do is your right. Everything that you wish to do is your fundamental right, except don't do those things which are prohibited by the British Parliament. So if British Parliament tells you don't murder, that's not your right. Don't commit rape, that's not your right. Don't indulge in corruption, that's not your right. Everything else is your fundamental right. Everything else is your fundamental right. But in India, there is a list of fundamental rights. Everything else is not a fundamental right. In US, there is a list of fundamental rights. Everything else is not a fundamental right. In Britain, everything is your fundamental right, so long as it is not prohibited by the British Parliament. Why British Parliament? Because British Parliament is sovereign. What is sovereign? You can make a decision, you can unmake a decision. You can do anything that you want to do. And British Constitution, since it is unwritten constitution, and in an unwritten constitution, it is the Parliament which is supreme. In a written constitution such as India, such as United States of America, in a written constitution, which is supreme? Parliament or the Constitution? Constitution. So Constitution is supreme. But in Britain, since they have an unwritten constitution, and in an unwritten constitution, it is the Parliament which is sovereign. It is the Parliament which is supreme. British Parliament can do anything. And that's what D. Lolme said. British Parliament can do anything except convert a man into a woman and a woman into a man. Which means British Parliament can do tomorrow pass any law and repeal that law as well, add one right to the people, deprive people of that right. There is no limitation on the powers of the British Parliament. British Parliament can do anything. And the courts in England, they're helpless when it comes to the legislature. But they will protect you against the executive. What does that mean? Listen to me carefully. What is the status of fundamental rights in England? What is the status? We say, number one, there is no code of fundamental rights. What is there is no code of fundamental rights? There is no such list that these are the fundamental rights enjoyed by the people of England. Okay, then what is the right that they have? They can do anything that they want to do, and anything that they do becomes their right. Except they should not do those things which are prohibited by the parliament. Except the things that are prohibited by the parliament, do anything that you wish to do. For example, it's like, if you believe in that story, Adam and Eve. God had asked Adam and Eve, specifically told him, eat anything that you want to eat, except that fruit. Don't eat that, don't touch that. Apart from that, everything you can have and enjoy. That means everything is the fundamental right, except eating that fruit. Similarly, in England, everything becomes your fundamental right, except don't do those things which are prohibited by the British Parliament. And British Parliament is sovereign. It can do anything. It can make any law. It can unmake any law. There is no limitation on the British Parliament, because British Parliament is supreme, sovereign. It can do anything. And if, for example, one right has been violated in England, which is that right? Let's say British Parliament says homosexuality is not a crime. For example, British Parliament says homosexuality is not a crime. And if there is a couple, a gay couple or a lesbian couple, they are together, the police arrests them. Police is part of executive. The police arrests them. The police can be dragged to the court. The court will be asked, how can you arrest me? Is homosexuality a crime? No, it's not. That means homosexuality is my fundamental right. How dare you arrest me? The courts in England will punish the police. How dare you arrest these individuals? Don't you know that homosexuality is not a crime? You are set free. Please go and enjoy. But if legislature of England tomorrow passes a law and says homosexuality is a crime, somebody indulging in homosexuality will be arrested and will be booked. And the courts will be helpless. Courts will not ask the parliament, why have you passed homosexuality as a law which becomes a crime? The courts will be helpless. Why? Because in Britain, parliament is sovereign. There is no limitation on the British Parliament, because British Parliament, according to D. Lowell May, can do anything except convert a man into a woman and a woman into a man. That's the status of fundamental rights in Britain. So in short, there is no right which may be said to be fundamental in the strictest sense of the term, because any right can be deprived by the British Parliament. British Parliament can do anything. Then, sir, why British Parliament does not delete right to information as a fundamental right, or provides freedom of speech and expression to the media or to the citizens? Because they are a mature democracy. And any parliament, any government, if it tries to bring such a law, that government will be voted out of power the next time. That is why their political class, they have to act maturely. Otherwise, they will face the wrath of the people. Otherwise, the people will vote them out of the power. So since they are matured as a democracy, that is why a large list of rights are available to the British people. But in short, there is no such thing as fundamental right. Because when we say it is fundamental, that means Parliament cannot violate these rights. When we say it is fundamental, Parliament cannot snatch these rights. But in England, there is no limitation on the power of the Parliament. Parliament can do anything. Is that clear? Any questions as of now? Okay. So legal rights include constitutional rights and statutory rights, correct or not? Yes, legal rights includes all rights provided by the law. Law can be a statute, law can be the constitution. These are all legal rights. Why this is so in England? Different countries function differently. That is why there should be diversity in the world as well. Why should they follow what we follow in India or what is followed in United States? They have their own culture, they have their own political beliefs, they have their own political wisdom, and they are working just fine having this existence. Okay. Then why right to vote is not a legal right? When did I say right to vote is not a legal right? Right to vote is not a fundamental right. It is constitutional right. Sir, right to information is a constitutional right under Article 19. There is one specific form of right to information which is a fundamental right under Article 19(1)(a). That we will discuss in Article 19. But that right to information, where you can approach the public authority, seek information about them, how they are spending the money, that is a statutory right provided by RTI Act 2005. Clear? Okay. Now the framers of the Constitution of United States, they realized that we have to protect people from two. In England, people are protected only from the executive, not from the legislature. Legislature can do anything. But the framers of the Constitution of United States, they wanted to ensure that we have to protect people not only from executive, but also from the legislature. And that is why US Constitution talks about a Bill of Rights, a set of fundamental rights, which are equally binding on both legislature as well as the executive. Neither can the executive violate these rights, nor can the legislature violate these rights. These rights are fundamental for the growth, development of an individual. Neither the executive nor the legislature can violate these fundamental rights. So if the legislature is violating your fundamental rights or executive is violating your fundamental rights, the courts will have supremacy. So in England, they have parliamentary supremacy, which means parliament is supreme. In United States, it is judicial supremacy. Judiciary is powerful. Judiciary will protect you. If executive is violating your rights, judiciary will come to your rescue. If the legislature is violating your rights, judiciary will come to your rescue. That means if legislature is passing a law which violates this Bill of Rights, judiciary will strike it down saying this law is unconstitutional. If executive is violating your rights by wrongly arresting you, by wrongly detaining you or torturing you, the judiciary will come to your rescue, because in US, they have the concept of judicial supremacy. But when it comes to fundamental rights in US, in India, we follow a similar American model rather than the English model. Similar American model rather than the English model. That means in India also, fundamental rights, whether the executive or the legislature is violating, don't worry, go to the Supreme Court. Supreme Court will protect your fundamental rights. That means when it comes to fundamental rights, we closely follow the American model as against the British model. Because in Britain, courts can protect you against executive, but courts cannot protect you against the legislature. Legislature can do anything. But in America, courts will protect you against executive as well as legislature. In India as well, we follow American model. That means the courts in India will protect you against executive, protect you against the legislature as well. But this concept of judicial supremacy, which is huge in United States, powers of judiciary in India are a little weaker than in United States. Why? Listen to me carefully. We have fundamental rights mentioned in the Constitution. Majority of these fundamental rights, or should we say almost all these fundamental rights, except one, which we will discuss later, all these fundamental rights are not absolute. They come with exceptions. Exceptions in the sense, I have the freedom of speech and expression. I can say whatever I have to say. I can express whatever I have to express. But that doesn't mean I can say anything. There is a limitation. Say anything, but don't go against the sovereignty and integrity of India. Say anything, but don't go against security of the state. Say anything, but don't violate public order. Say anything, but don't violate friendly relations with foreign states. Say anything, but don't commit contempt of court. Say anything, but don't say it defamatory. Say anything, but don't incite people to violence. That means Constitution, on one hand, is giving you a fundamental right, and on the other hand, is imposing restrictions on your fundamental rights as well. Constitution says every single person in India will have the right to life and liberty. But the same Constitution says this can be snatched as well. Your life can be snatched, your liberty can be snatched, according to the procedure established by law, which we will discuss what that is. So it is like father giving you 1,000 rupee as pocket money. Beta, this is for you. Chocolates. You're happy. 1,000 rupee. But then the father says, whatever money I have given you, pay electricity bill using this money. What are you saying? Giving you money. Take money. But use this money to pay electricity bill. So this is like the Constitution, giving you a list of fundamental rights, but the same Constitution is imposing limitations on your fundamental rights. You have freedom of speech and expression, but restriction on these grounds. You have right to life, but restriction. You have right to equality, but restriction. You have right against discrimination, but restriction. You have cultural rights, but restriction. You have religious rights, but restriction. So restrictions are imposed by Constitution itself. But in United States, if at all, there should be restriction on your fundamental right. If at all, there should be restriction on your right to life. If at all, there should be restriction on your freedom of speech and expression. If at all, there should be restriction on your freedom of press, freedom of media. Those restrictions can be imposed by the judiciary. That is why we say the powers of judiciary vis-a-vis legislature in India, they are weaker in India than the United States. Why? Because if there are fundamental rights, and on these fundamental rights, restrictions can be imposed. Restrictions can be imposed by the US Supreme Court when it comes to United States. But in India, restrictions on your fundamental rights can be imposed by the Parliament. Some restrictions are already mentioned in the Constitution. If further restrictions are to be made on your freedom of speech and expression, on your fundamental rights, those restrictions can be imposed by the legislature in India. Long story short, when we look at fundamental rights and compare the models in England, in United States, in India, what is the big picture that we get? The big picture is, in England, everything is your right, unless and until you don't violate the law passed by the British Parliament. Because British Parliament is supreme, it can do anything. Unless and until British Parliament prohibits you from doing anything, whatever else you want to do, that's your right. And in England, legislature can do anything, which means legislature is supreme, is sovereign, which means judiciary can protect you against executive if executive has violated your rights, but is helpless when it comes to legislature. In United States and India, in United States, there is a list of fundamental rights. These are fundamental rights. And the courts will protect you against executive if executive is violating your rights. courts will protect you against the legislature if the legislature is violating your rights. So in US, they have a concept of judicial supremacy. In India, we also follow a system of coding of fundamental rights. There is a code of fundamental rights. There is a whole list of fundamental rights between Articles 25 and 35, between Articles 12 and 35. And these fundamental rights are enforceable. In a sense, if executive is violating your rights, court will come to your rescue. If legislature is violating your rights, the court will come to your rescue. But judicial supremacy in India is little weaker as against United States. Why? Because if in United States there are fundamental rights provided to you, if restrictions are to be imposed, if limitations are to be imposed on your fundamental rights, those limitations can be evolved through judiciary. Judiciary can impose restrictions. But in India, if there are limitations, restrictions imposed to be imposed on your fundamental rights, those can be imposed by the legislature, not the judiciary. That is why we say, although we follow the concept of supremacy of the Constitution, because Constitution is supreme in India, just like in United States. Just like in United States, we also have a list of fundamental rights. Just like in United States, court can protect you against legislature as well as executive. But if there are limitations, restrictions to be imposed on your fundamental rights, in US, judiciary can do that. In India, parliament can do that. That's the whole picture. Anything as of now, any questions as of now, let me know. Ordinary law of land means the law passed by the parliament through simple majority, which is an ordinary law. How legislature can impose, sir? There is a doctrine of basic structure. If I say everything now, how will you understand? Allow me some time. We'll cross the bridge once we reach. We'll discuss basic structure later. All legal rights are not fundamental rights. No. Is right to live equivalent to right to die? No. You only have right to life, you don't have right to die. So, sir, judiciary in US is more powerful than in India. But we say over a period of time, it is the Indian judiciary which has become powerful as against the US judiciary. In some aspects, it's the US judiciary. We'll discuss that in judiciary chapter in great detail. What all are included under basic structure? Not all fundamental rights are part of the basic structure. To tell you here, right to property was initially a fundamental right, but it was deleted from the list of fundamental rights in 1978 because right to property was not declared as part of the basic structure of the Constitution. So all those fundamental rights which are part of the basic structure cannot be deleted, cannot be modified, cannot be abridged. Remaining can be. Who is supreme in China? The head of the Communist Party, Xi Jinping, is the supreme leader. Okay. Now let's understand and explain all these fundamental rights between Articles 12 to 35. First, we will look at Article 12. What is Article 12? Throughout the discussion on fundamental rights, we will come across a term known as state. Is it the state of Andhra Pradesh or the state of Karnataka? What is the state? The definition of the state is given under Article 12. So when the Constitution says the state shall not deny equality, who is the state? The state shall not discriminate. Who is the state? Who is the state against which you can claim your fundamental rights? The state shall not do this, the state shall not do that. Who is the state against whom you can go to the court for the protection of your fundamental rights? That definition of the state is given under Article 12 of the Constitution. And what does Article 12 say? Article 12 says state includes Legislature of India, which means the central legislature, Parliament, Government of India, which means President, Prime Minister and his Council of Ministers, State Government, which means Governor, Chief Minister and his ministers, State Legislature, which means the State Legislative Assembly, State Legislative Council, local bodies such as Panchayati Raj institutions, municipalities. All those are part of the state under Article 12. And if they violate your fundamental rights, drag them to the Supreme Court. So when the Constitution says the state shall not deny equality, and if they deny equality, you can drag them to the court. Who is the state? State means Parliament of India, legislature of a state. If they violate your fundamental rights, take them to the court. State means the Government of India, the government of a state. State means Panchayati Raj institutions, urban local bodies, municipalities, municipal councils. If all of them or any of them violate your fundamental rights, drag them to the court, because these fundamental rights you can claim from the state. If the state is violating your fundamental rights, denying you your fundamental rights, drag the state to the court. But then something else in the sense, Article 12 says, state includes government and Parliament of India, government and the legislature of each of the states in India, all the local bodies and other authorities within the territory of India are under the control of India, Government of India. Which are these other authorities? We do not know. Why? Because other authorities have not been explained or defined in Article 12. Article 12 does define. The state means Government of India, Parliament of India, Government of State, Legislature of State, local bodies, defines everybody. But it also says other authorities. State also includes other authorities. Which are these other authorities? Within the territory of India and which are under the control of the Government of India. Those are other authorities. But which are these other authorities? We don't know, because they have not been explained, they have not been defined in Article 12. And when there is something ambiguous, something which is not clear, and we need clarity, where do we go? We go to the court. You're reading Laxmikanth, but you're not able to understand. To interpret Laxmikanth, where do you go? You come to me. Clear? Who is the final interpreter of the Constitution? Supreme Court. Supreme Court was approached. Supreme Court, can you tell us, are you the interpreter of the Constitution? Supreme Court said, yes, 100%. Please come. Which interpretation do you seek? In Article 12, there is something called state. And yes, we know that. We have read it. So in state, it says we can claim fundamental rights against the state. Yes. So the state is violating your fundamental rights. Come to us. We will protect your fundamental rights. It defines that state means Government of India, Parliament of India, Government of State, Legislature of State, local authorities. But it also tells us something called other authorities. Which are these other authorities? Which are also included in the definition of the state. Which, if they violate fundamental rights, we can bring them before you. Which are these other authorities? Supreme Court said we can elaborate. And we will basically give you 5 cases. We'll basically give you 5 instances, or we will give you 5 explanations of who are these other authorities within the meaning of Article 12. The Supreme Court said, number 1, those authorities, financial resources of the state, where the state is the chief funding, that means the entire share capital is held by the government. What does that mean? There is a public body, for example, public sector undertakings, or for that matter, Reserve Bank of India, or for that matter, the State Bank of India, or for that matter, the Life Insurance Corporation of India, or for that matter, Food Corporation of India. So what are you trying to say? Any authority, any institution, any body where the principal owner of this body is the government, where majority stakeholder is the government, where more than 50% shares are with the government, where the government is the principal funding source, that entity also is a state. And if these violate your fundamental rights, bring them before us, we will give you your fundamental rights. Although LIC, RBI, State Bank of India, Food Corporation of India, these are not mentioned as the definition of the state under Article 12. But Article 12 includes them. Why? Because it talks about other authorities. And which are these other authorities? Those other authorities whose principal stakeholder, majority stakeholder, chief funder is the government. Whether government of India or government of a state, that entity becomes state under Article 12. Deep and pervasive control of the state. Deep and pervasive control of the state. If there is an authority, and this authority, government has the ultimate control over it. Which is that authority? Railways, Indian Railways. Is Indian Railway mentioned under Article 12 that it belongs to, it comes under the category of state? And if the railways violate your fundamental rights, you can drag the railways to the court? It's not mentioned there. But it is part of other authorities. Why other authorities? Because the state has the deep control over railways. Where the railway lines will be laid, how the employees will be appointed, how the employees can be removed, how the funding will be given. Budget is allocated to the railway by the government of India. It has a deep and pervasive state control. It is a state under Article 12. Third, if the functional character is governmental in its essence, meaning that its functions have public importance or are of governmental character. Hospitals, government hospitals, they perform public function. Government hospitals are part of Article 12. Is it mentioned originally in the Constitution? No. But these are other authorities because their function is governmental. These are other authorities because their functional character in essence is governmental in nature, to provide chikitsa, or what is called as to provide health benefits to the people. Government hospitals are within the meaning of state. So if hospitals, government hospitals are violating your fundamental rights, drag them to the court. Similarly, a department of government transferred to a corporation. For example, we had Doordarshan and All India Radio. These were part of Ministry of Information and Broadcasting. These were part of Ministry of Information and Broadcasting. But in the 70s, Doordarshan and All India Radio was transferred to a corporation. That means a company was created, known as Prasar Bharati. Now, Prasar Bharati owns Doordarshan, All India Radio. Since it was a department of the government under the Ministry of Information and Broadcasting, but then it was converted into a company. It was established as a corporation. Prasar Bharati entity was created. Prasar Bharati is a state under Article 12 of the Constitution, which means if Prasar Bharati violates your fundamental rights, drag Prasar Bharati to the court. Any other entity which enjoys monopoly status and is protected by it. For example, if there is one entity which deals with atomic energy, And only this entity has the power, has the responsibility of dealing with atomic energy. The government has provided monopoly to this. Then this also becomes part of Article 12. You can drag it to the court. For example, if tomorrow, thanks to Mr. Ambani, if Airtel also collapses, BSNL already is in ruins. Vodafone Idea is almost gone. Now the government is trying to save it. But what if the only entity which remains is Reliance Jio? Reliance Jio will have the monopoly over telecom sector in India. Monopoly in the sense there is no other player in the market. Everybody is the customer of Reliance Jio. That means Jio has the monopoly over the telecom sector. Jio. If this monopoly status is given by the state, if the government says, yes, from now onwards, Jio will have the monopoly over the telecom sector, just like railways has the monopoly, Indian Railways has the monopoly over the railways. In the similar fashion, if Reliance Jio has the monopoly, is given monopoly over telecom by the government, Reliance Jio becomes a state under Article 12. If Reliance Jio would violate your fundamental rights, you could drag Jio to the court. What does that mean? Article 12 of the Constitution, which starts Part 3 of the Constitution, because Part 3 deals with Articles 12 to 35. The first thing that we need to understand is who is a state? What is a state? Because Constitution says the state shall not deny equality. The state shall not do this. The state shall not do that. That means you can claim all your fundamental rights against the state. How? For example, one fundamental right is fundamental right to public employment. That means whenever government invites applications for government jobs, there should be no discrimination whatsoever. But tomorrow, Byju's invites applications for jobs. That we need teachers, we need tech developers, we need product managers, we need technical managers, we need social media managers, we need a marketing manager, we need somebody, we need a chief financial officer, for example. Can Byju's violate your rights? Yes. Does Byju's have to treat all of you equally? No. Why? Because Byju's is not a state under Article 12. Only those entities which are part of the state, if they violate your fundamental rights, you can drag the state to the court. Byju's is not a state under Article 12 of the Constitution. Similarly, BCCI, Board of Control for Cricket in India, it is not a state under Article 12 of the Constitution, which means there is one player who has performed very well in the domestic circuit. Now there is news. I don't know what's his name. Can somebody tell me the name of that player? Slightly, not Raidu, a cricket player who is playing very well in the domestic season. Shahnawaz Khan or Sarfaraz Khan. He is denied a test berth. He is not selected for the test team. Can he approach the court and say, my fundamental right to equal treatment has been violated by the BCCI? No. Why? Because BCCI is not a state under Article 12. But sir, isn't BCCI having monopoly? Monopoly in the sense, only the BCCI can select cricket team which can represent India. Only the BCCI can have cricket tournaments in India. Isn't BCCI having monopoly over cricket? Yes, BCCI is having monopoly over cricket. But that's not the only criteria to call BCCI a state. You should have the monopoly status, and this monopoly status either should be conferred by the state should tell you that you have the monopoly over cricket, or the state should protect your monopoly status. You're having monopoly over cricket, yes, absolutely fine. But this monopoly status is not given by the state. This monopoly status is not presented or preserved, protected by the state. As such, BCCI is not a state. So how can you say this? I can say this because there is a judgment, Z Telefilms versus BCCI 2006, where it was argued that BCCI is not a state. So what is the state? It says Government of India, Parliament of India. Government of state, the legislature of the state. Urban local bodies, the local bodies in urban areas and in rural areas, Panchayati Raj institutions, they are part of the state. If they violate your fundamental rights, drag them to the court. Claim your fundamental rights against them. But then Article 12 also talks about other authorities. Other authorities, other than these. Which are these other authorities? Supreme Court said, tomorrow, for example, you're filing a case. You're filing a case against an entity X, saying X has violated my fundamental rights. First, the court will have to satisfy itself that X is a state, because you can claim your fundamental rights only against state. You cannot claim your fundamental rights against private bodies. You cannot claim your fundamental rights against Adani or Ambani or Tata, because these are not states. These are private entities. You can claim fundamental rights against the state. For that, Supreme Court has said we will look at 5 tests. 5 tests will be performed to check whether X is a state or not. 1, if the financial resources of X are majorly funded and contributed by the government, if the government is the major stakeholder in this entity, if yes, it is a state. If no, another test. Does the state have the power to appoint individuals to this body, remove individuals from this body? Does the state have the power to manage this body? If not, then it is not a state. If yes, then it is a state. If, for example, the purpose of this entity is governmental, for example, there can be entities, pollution control boards, although these are not governmental bodies, but pollution control board, their function is governmental. In the sense, government has the role to control pollution, curb pollution, and these pollution control boards have the same function to curb pollution. Pollution control board is a state under Article 12. If they violate your fundamental rights, drag them to the court. Similarly, if it was once a department of the government, but now converted into a corporation, then it is a state. If not, does it have a monopoly? But this monopoly should be conferred by the government or protected by the government. If yes, then it is a state. Otherwise, it is not a state. That is Article 12 of the Constitution. Any questions as of now? Sir, fundamental rights are not negatively verdict, but some are positively verdict. Please tell correct or not. What is verdict? Positively worded or verdict? Some are positively worded as well. Some are negatively worded. Most are negatively worded. Is this 5 checks provided by the court? Yes. What was said by court in BCCI case? That BCCI is not a state under Article 12. Byju is a state or not? Byju is not a state under Article 12. Are political parties a state? No. That is why they don't come under RTI as well. Okay. Now let's look at Article 13 of the Constitution. Laws inconsistent with or in derogation of the fundamental rights. Here we'll have to discuss 4 clauses. 13, Clause 1, Clause 2, Clause 3, Clause 4. But you don't have to remember clause by clause, just understand the concept. And what is the concept? Number 1, Article 13, Clause 1. This is, or let's put it this way, let me add a slide. This is 26th January 1950. What happened on this date? Constitution was enacted. Constitution entered into force. Now let's say there are laws prior to the commencement of the Constitution, which are in force in India prior to the commencement of the Constitution. Which are these laws? For example, IPC. When was Indian Penal Code enacted? 1860. Lord Macaulay was the drafter of this code, Indian Penal Code. So Indian Penal Code is a pre-constitutional law. That means it entered into force prior to the commencement of the Constitution. Now this Article 13 Clause 1, what is it saying? Laws prior to the commencement of the Constitution. If these laws, let's say IPC, now Constitution has been enacted. If this law is in agreement with fundamental rights, some laws can be in agreement with fundamental rights because IPC was created, enacted when there was no such thing as fundamental right in the Constitution. So these laws, which are pre-constitutional laws, may be in agreement with fundamental rights. Some will have provisions which are violative of fundamental rights. What will happen to these laws? Article 13 Clause 1 says, those laws which are in operation prior to the commencement of the Constitution, if they are in agreement with fundamental rights, these laws will continue after 1950 as well. But those laws which are violative of fundamental rights, which are not in agreement with fundamental rights, they will not continue, they will stop. Because fundamental rights are very important. And these laws which are violative of fundamental rights, that's what the Constitution says. To the extent of such inconsistency be wide. What does that mean? Listen to me carefully. This is section 377. We discussed yesterday. Section 377 talks about unnatural offense. What is an unnatural offense? Having a carnal intercourse, which is against the order of nature, it is an unnatural offense, 5 years in jail. This is a pre-constitutional law. Is it? Done. Then came 26th January 1950. Is this in agreement with fundamental right? If yes, it will continue. If not, it will not continue. But who has to decide whether it is in agreement with fundamental rights or not? Who is the final interpreter of the Constitution? Supreme Court. Clear? One more thing. Doctrine of severability. Sever. Cut something. Clear? Unnatural offense deals with homosexuality, bestiality, incest. For example, homosexuality, sex with the same gender. Bestiality, sex with animals, for example. Incest, mother having sex with son, father having sex with daughter. That is incestuous relationship. It is an unnatural offense. It is a crime. In the year 2018, it was declared that homosexuality is not a crime. Section 377 was read down. That means it was not declared unconstitutional. Only one part was declared unconstitutional, which means only one part was severed, only one part was cut. Remaining is still constitutional. Remaining is still a crime. Bestiality is still a crime. Incest is still a crime. That is what we say, all laws in force in the territory of India immediately before the commencement of the Constitution. all these laws which were in force prior to the commencement of the Constitution, whether it is Indian Penal Code, whether it is Civil Procedure Code, whether it is Muslim Personal Law, Shariat Application Act 1937, any law which is in force prior to the commencement of the Constitution. Now, once Constitution has been enacted, if these laws are in agreement with fundamental rights, they will continue. If these laws violate fundamental rights, they will not continue. But this is where we have to come across a term known as doctrine of severability. What is doctrine of severability? That means insofar as they are inconsistent with the provisions of this part, if they are inconsistent, if they violate this part, to the extent of such inconsistency, they will be declared void. That means if only one part of section 377 violates fundamental rights, what is that one part? Homosexuality. Homosexuality is deleted. Homosexuality is not a crime. That means only homosexuality was inconsistent with fundamental rights. This has been read down. But the entire section not only talks about homosexuality, it talks about incest, it talks about bestiality. Those will still continue because these are not inconsistent with fundamental rights. Bestiality is still an unnatural offense. Incest is still an unnatural offense. It does not violate fundamental rights. That means only those parts will be cut. Only those parts will be severed which violate fundamental rights. The rest of the article will continue. Which means if IPC has hundreds of sections, only one section of IPC violates fundamental rights. Only that section will be cut. Remaining will continue. If there is a body and in only one part of the body there is tumor, we cut the tumor or we cut the part where there is a tumor. We don't kill the entire person. Similarly, if IPC has a lot of sections, IPC is a pre-constitutional law. If only one provision or few provisions are violation of fundamental rights, those provisions will be severed, will be cut, rest will continue. Within one section as well, if there is section 377, one section is unconstitutional, rest is constitutional. Those which are constitutional will continue, those which are unconstitutional will be severed, will be cut. That is what we call doctrine of severability. That is clause 1 of Article 13. In simple terms, if there is a pre-constitutional law which is in force prior to the commencement of the Constitution, because during the British period, lots of laws were passed which are in operation even today. Lots and lots of laws. If these laws are in agreement with fundamental rights, they will continue. If they violate fundamental rights, they will be declared unconstitutional. Clear? Done? Article 13, clause 2. It says the state shall not make any law. What the state cannot do, it cannot make any law. Through this law, what it cannot do, it cannot delete a fundamental right, it cannot modify a fundamental right, it cannot abridge a fundamental right. That is not the power available with the state. And if the state still goes ahead with this, it will be declared void, unconstitutional. This is where we encounter a term known as judicial review. What is judicial review? Power of the judiciary to review the laws passed by the parliament, to review the rules or actions of the executive. That's the power of judicial review. This term judicial review is not mentioned anywhere in the Constitution. Nowhere in the Constitution does the Constitution say that Supreme Court will have the power of judicial review. Yet judicial review is part of the basic structure of the Constitution. Why? Because what is a Constitution? Whatever Supreme Court says, that is the Constitution. So if the Constitution has said judicial review is part of the basic structure of the Constitution, it is part of the basic structure. But how can we say judicial review is mentioned in the Constitution when such a word does not exist? We can trace this concept. Although it's not mentioned anywhere, We can trace that concept of judicial review exists under Article 13 Clause 2. Because what 13 Clause 2 says, state cannot pass any law which deletes fundamental rights, which modifies fundamental rights. And if the state modifies, deletes, abridges a fundamental right, that law will be declared void. Who will declare that law? We can assume that law will be declared unconstitutional by the judiciary. And that is the power of judicial review. But Constitution says state shall not pass any law which can delete, modify, abridge a fundamental right. And what is this law? Tomorrow there can be a confusion on this. What is a law? We don't know what is a law. Article 13 Clause 3 explains, gives us the explanation of what is the law. Article 13 Clause 3 says, law is an act, law is a rule, law is a regulation, law is an ordinance passed by the president or the governor. Law means rules, customs, usages, bylaws, notifications. Everything is a law. And through all these things, you cannot delete, modify, abridge a fundamental right. When you cannot delete, when you cannot modify, when you cannot abridge a fundamental right, then something happened in 1951. Fundamental right was changed. And we will discuss that in directive principle, how that happened. But very briefly here, original constitution said under Article 15 that there can be no discrimination. The state cannot discriminate only on the grounds of religion, race, caste. Madras government, it was then called Madras, it issued an order that we will provide reservation in government jobs, in engineering and medical colleges, in government institutions. We will provide reservations to SCs and STs. Matter went to the court. The court was asked, Madras government has violated fundamental right. Said yes. Is Madras government a state? Yes, it's a state under Article 12. Which fundamental right has it violated? Article 15. How? Because Article 15 says the state shall not discriminate only on the grounds of caste. But since you are providing reservation to SCs and STs in engineering and medical colleges in Madras, primarily because of your caste, that is why you are violating fundamental rights. Supreme Court said, yes, Madras government, what are you saying? What are you doing? You're violating fundamental rights. How dare you? We have the power of judicial review. This reservation is unconstitutional. Parliament realized that things are going bad. We have to provide reservation on the basis of caste. Parliament got together, amended the constitution, amended fundamental right, and said for socially and educationally backward classes of citizens, such as SCs and STs, we can provide reservation. We can provide benefits. Clear? Now this matter went to the court. The court asked, why are you here? My lord, there is Article 13 Clause 2. Said, we know that, but what are you trying to say? Said, it says the state shall not make any law which takes away a fundamental right, which modifies a fundamental right. Said, what has happened? Sir, Parliament has modified a fundamental right. Said, which fundamental right? Sir, Article 15. How? Sir, Article 15 said there can be no discrimination on the grounds of caste. Said, okay. And what have the government done? Sir, Parliament has said for SCs and STs, only on their caste, they will be given reservation. The Supreme Court asked the government Attorney General, what are you doing? Sir, this is our power. We have the power to make law. We have passed a law. Under what provision have you passed a law? Sir, Article 368. What is 368? Sir, we have amended the constitution. Okay, but don't you know there is Article 13 Clause 2 which says you cannot pass any law? Yeah, that we know. So Article 13 Clause 2 says state cannot pass any law which deletes, modifies, abridges a fundamental right. But you have done that by passing a law under Article 368. Yes, sir, but that law is different. Sir, how is that different? Sir, because Article 13 Clause 3 explains what are these laws through which you cannot delete, modify, abridge fundamental right. So where is it mentioned? Sir, Article 13, Clause 3. It says through ordinance you cannot, through order you cannot, through bylaw you cannot, through rule you cannot, through regulation you cannot, through notification you cannot, through custom you cannot, through usage you cannot, through all these things you cannot delete, you cannot modify, you cannot take away fundamental right. But we have not taken away fundamental right, modified fundamental right through this. We have modified fundamental right through a Constitutional Amendment Act under Article 368. Is it mentioned in Article 13, Clause 3 that even through Constitutional Amendment Act, you cannot take away, you cannot modify, you cannot abridge a fundamental right? No, it's not mentioned. That means Parliament has the power to do anything using Article 368. Using Article 368, we can do anything. We can delete fundamental right, modify fundamental right, abridge fundamental right, add fundamental right, whatever we want to do. The court said, yes, you're right. Please go ahead. Now we will say, through an ordinary law, you cannot do this thing. Through an ordinary law, you cannot take away fundamental right. You cannot abridge, modify a fundamental right. If you want to delete fundamental right, if you want to add fundamental right, if you want to modify fundamental right, don't do that through an ordinary law passed by simple majority. Do that through a Constitutional Amendment Act passed under Article 368 by special majority. So that's what we have done. Okay, thank you. Bye-bye. Few years later, 1967, another case went to the court. And this case is known as Golaknath versus State of Punjab. We will discuss all these cases in detail when we will talk about Keshavananda Bharati case. But here, it's just to make you understand Article 13. In Golaknath case, Supreme Court said, no, even through a constitutional amendment, you cannot delete, modify, abridge fundamental right. The government said, sir, what are you saying? I repeat, even through a constitutional amendment passed under Article 368, you cannot take away, you cannot modify, you cannot abridge fundamental right. Sir, how can you say this? Article 13, Clause 3 explains that law means ordinance, order, bylaw. It has explained everything. Constitutional Amendment Act is not mentioned here. So through a Constitutional Amendment Act, we can delete fundamental right, modify fundamental right, because that's an exception. No, you can't do that. Sir, how can you say this? Look at Article 13, Clause 2. What does it say? State cannot make any law. Any means any. Any means including constitutional amendment. Don't you dare touch fundamental rights. Fundamental rights are basic, fundamental for the growth and development of an individual. Don't you dare touch fundamental rights. Parliament, you do not have the power to even use Article 368 to delete, modify, abridge fundamental rights. That's not your power. Indira Gandhi was the Prime Minister. Indira Gandhi sat with her colleagues and said, what's happening? Madam Gandhi, 1951, Supreme Court said, don't through an ordinary law, but through a Constitutional Amendment Act, you can delete, modify, abridge fundamental rights. Now, what are they saying? Now they're saying even through Constitutional Amendment Act, you cannot delete, modify, abridge fundamental rights. Is it mentioned anywhere in the Constitution that Constitutional Amendment Act is different and law is different? No, ma'am, it's not mentioned anywhere because Article 13, Clause 2 says Parliament cannot pass any law. And explanation of this law is given in Article 13, Clause 3, which says rules, customs, bylaws, usages. But we can't say law is different and a Constitutional Amendment Act is different. Indira Gandhi asked her legal advisor, what do we do? He said, let's amend the Constitution. What do we write? Let's add Article 13, Clause 4 in the Constitution. What will happen because of this? Ma'am, we will create an exception. What is that exception? We'll say law is different and a Constitutional Amendment Act under Article 368 is different. Then what will happen? If Article 13, Clause 2 says you cannot pass any law to delete, take away, modify, abridge fundamental right, but law means only these things. Only through these you cannot delete, modify, abridge fundamental right. We will add specifically in the Constitution there is an exception. The exception is nothing in this article shall apply to the amendment of the Constitution made under Article 368. What is in this article? That Parliament cannot delete, take away, abridge fundamental right. That will not apply. That limitation that you cannot delete, modify, abridge a fundamental right, that limitation will not apply to the amendment of the Constitution under Article 368. This was done in 1971. Again, this went to the court. The Supreme Court upheld this. In Keshavananda Bharati, Supreme Court said, yes, there is no problem with this. But only through a Constitutional Amendment Act under Article 368, you can delete, modify, abridge a fundamental right. But that will also be subject to basic structure. A fundamental right which is part of the basic structure, don't you dare touch it. Apart from that, you can touch any fundamental right, modify fundamental right, abridge fundamental right, but not through an ordinary law, not through an ordinance, not by executive issuing a rule, but only through a Constitutional Amendment Act passed under Article 368 by special majority. So if you have to understand in simple terms what is Article 13, Clause 1, 2, 3, 4, what's the crux of this? This is 26 January 1950. All laws prior to the commencement of the Constitution. Can these laws continue after 1950? Yes, if they are in agreement with fundamental rights. If they are not, they will not continue. Parliament does not have the power to delete, modify, abridge a fundamental right through an ordinary law. Through an ordinary law which is passed by simple majority. But Parliament can delete a fundamental right, modify a fundamental right only through a Constitutional Amendment Act passed under Article 368 by special majority. And even then, those fundamental rights which are part of the basic structure, which we will discuss later, those fundamental rights which are part of the basic structure, Parliament cannot touch them because they are beyond the amending powers of the Parliament. That's Article 13. And tomorrow when we meet, we will start with Article 14, right to equality. And tomorrow we will discuss some fascinating judgments on reservation. So see you tomorrow at 6 o'clock in the morning. But if you have any questions, let me know. Sir, so why now caste-based reservation is provided? We'll discuss that tomorrow. So Ripan, come tomorrow. We'll discuss all the related cases of reservation. Which chapter to be done from NCRT and Laxmikanth? Don't read NCRT, read Laxmikanth. Finish the chapter Preamble, Union and its Territory, and Citizenship. Finish these 3 chapters. Let me know if you have any doubts. Don't read Fundamental Rights from Laxmikanth. Thank you so much for staying here. We'll meet again tomorrow, 6 o'clock in the morning. Till then, whatever doubts you have, get in touch with the subject matter experts. They'll be able to help you. Bye-bye. Take care. Goodbye. Lakshmi, what is your question, please? Lakshmi, if you're here, please. What's your question? Private schools are not state. They have their own rules and regulations. Okay, Lakshmi is not here. Okay, bye-bye. See you tomorrow, 6 o'clock in the morning.